Mm-hmm. I couldn't even get it in the phone. I'm trying to hook into the computer. I got this phone, but I'm just gonna go down here to this here.
So you in the car? You in the Zoom call?
I'm gonna leave this here right there.
You gotta turn your audio off on the call.
Look,
Don't touch nothing.
Look, they turn stuff up. Don't touch.
Review Police Department to file a PPO.
And besides, you indicated that when Mr. Gooch was employed under your supervision, he had called you before for about work issues.
Yes.
And did you ever receive any other phone calls from that number besides from Mr. Gooch?
That's correct.
So,
What's up, court nerds? Time to get served with your boy, Phil. How you doing, guys? What's up? Unbelievable. This ride is unbelievable. I can't believe it. I got some great court clips for you. Happy Valentine's Day. Hope you're spending with your loved ones. I'm glad you're here with me. I got clips all from today. I got an update for a woman in Judge Webster's court. They finally caught her. I also have from Judge Washington, just from everybody. Wyandotte doesn't disappoint. And Webster has a whole bunch of kids that she caught, and they're all on the docket, one after another. So let's get rolling.
All right, thank you. Please raise your right hand. You solemnly swear from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, my witness is looking into vehicles and he observed him inside a gray minivan. The witness was reporting the suspect was currently sitting in a dark-colored vehicle that was parked in the middle of the road. Officer Stromberg, Agrode, and Cox arrived and observed a black Chevy Malibu stopped middle of the road running, occupied by a lone white male later identified as the defendant Potts. To prevent Potts from fleeing the area, officers asked Potts to exit the vehicle, and as he did, a small black flashlight fell from his pocket. Potts was wearing a brown leather jacket with a hood pulled up over his head. Officers located a double-edged black knife with a pointed edge type knife in Potts' upper left jacket pocket. While speaking with Potts, Officer Stromberg was speaking with the witness, Thornton. Thornton stated he observed Potts exit his dark-colored vehicle and walk up the driveway at 20:37:22, look inside a vehicle with a flashlight. Thornton then watched as Potts walked to a 2017 Chrysler Pacifica parked in front of 20:51:20. Potts made entry into that vehicle. Officers located the owner of that vehicle who confirmed his vehicle was rummaged through, but nothing is missing. Officer Stromberg located a 2018 Chevy Traverse parked in the driveway at 20:37:20, saw that the glove box was open and the vehicle appeared to have been rummaged through. Officers contacted the vehicle owner, Mr. Russell Skitch, who confirmed his car was rummaged through, and he stated a blue satchel with the words Buffalo Whalen was written on it is missing from his vehicle. The bag contained wheel locks for Mr. Stitch's car. The bag was located inside of Potts' vehicle. On the window ledge directly to the left of the Stitch's vehicle, officers located 4 sets of keys. Each contained multiple keys to which Skitch stated they were removed from inside his vehicle. The bag and the wheel locks were photographed and returned to the victim. I spoke with the Chevy dealer. They stated the cost to replace the wheel locks would have been around $100.
I never
A resident,
I swear to God.
Why? A resident, Brandon Magola from 1880 19th Street, called dispatch and advised about 2 o'clock in the morning he has ring video of someone checking his vehicle. Officer Cox spoke with that victim who stated male stopped a dark-colored car at the end of his driveway. The driver wearing a dark-colored coat, his hood pulled up over his head, walked up his driveway attempted to get his vehicle. He sent that video to Officer Cox, who confirmed it was the defendant. Inside Mr. Potts' vehicle, officers located a plastic cup filled with chains, several small flashlights, a multi-tool, and a Christmas candle, and other miscellaneous items.
What?
All right, upon examination of pleading witness.
Here we go.
Then
Yikes.
the offense charge were committed, and there's probable cause to believe the defendant committed those offenses. And, sir, your name, please.
And a burger. Basically. Roman Potts.
All right, thank you. And counsel, as to, I think you've already placed your appearance on the record, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute.
All right, the court will waive the formal reading. Sir, you have the right to have an attorney if you cannot afford one. The court will appoint one to represent you. And in fact, you've had an opportunity to speak with an attorney today, correct?
I didn't have a chance to speak to one. I've asked so many times to speak to my father and speak to the suicide hotline. I've asked to speak to my lawyer.
Sir,
And my
okay,
parents
just one
gave me a lawyer.
moment. Just one moment. Do you see the individual sitting on the Zoom camera with the suit on with the glasses?
Yeah,
Okay. Did you have a chance to speak with him today?
yeah, but he didn't really let me talk a lot.
Okay. Well, he's an attorney, and so you had an opportunity to meet with him, correct?
Yeah, when I tried speaking, he just
Okay.
didn't really listen to me.
Okay.
Nobody loves
Well,
me.
sir, the court's going to indicate that you also, the court's going to sign the order for court-appointed attorney for felony matters. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yep,
I'm sorry?
yes.
Okay. And the court's going to enter plea of not guilty on your behalf. Schedule this matter for probable cause conference on February 23rd at 9 a.m. And counsel as to bond, and then I'm going to Detective Sergeant Grow an opportunity to address bond.
Yes, Your Honor. I did have an opportunity to speak with my client. I advised him of his constitutional rights as well as what he's being charged with, the maximum penalties. I did inform him what the procedure is as far as the next court date being a preliminary conference in which he still can maintain his innocence. He indicated that he does have gainful employment. Actually, he was supposed to start working yesterday at Tina's Tavern. He was going to be working full time. He indicates he doesn't have any other precluding issues that would stop him from coming to court. So he did humbly request the possibility of potentially having consideration for a personal bond. Thank you, Judge.
All right, Detective Sergeant Grow.
Your Honor, this gentleman has no ties to our community or even nowhere, even to this county. The potential for danger that night, if somebody confronted him while going through a car with the weapon he had, somebody could be severely hurt. We're gonna ask for 10,000, 10% against.
I've been to the strip club, I've been to many bars.
I'm sorry, it broke up. You said 10,000 what?
10,000, I guess, 10%.
I would never use that, I swear.
Mr. Potts, we have a system that records the record, and it cannot record when there's more than one person talking at a time. Okay, so please stop interrupting. Now, are you, what's going on with the matter out of Sterling Heights from January, the domestic violence charge?
I've been locating a lot of jail bond places, and I really want to pay the $1,000 jail bond. And that's why I held a job, because I was hoping to pay for it. And my family told me.
Hold on, Mr. Potts. You have a pending matter out of Sterling Heights, do you not?
A pending jail bond? Yes.
No. You have a pending case out of Sterling Heights.
Yes. Which I was supposed to go
Okay.
to, I think, today or yesterday.
Okay. Now, what were you going there for a pretrial, for sentencing? What were you going for?
I believe I was going there to pay my jail bond of $1,000. That's what I kept trying to tell everybody. I've been trying to tell so many people about my situation. I really need help, but nobody's listening to me.
Sir, just one moment.
Wrong judge to be doing this
Have
to.
you already been arraigned in that matter? Have you had any court dates in that matter already?
I've only had the one court date for the jail bond that I want to pay.
Okay. And who was the other individual involved in that incident in January?
That was Kimberly Bean. She was my ex. She was cheating on me with a lot of pretty much everyone in my complex. And she got literally domestically assaulted, violently raped, and stolen from, and she steals from me, and everyone tells her to do bad stuff to me, and she believes them because I'm the nice guy. And to be honest, I never knew that she was doing that in the beginning. But then when the cops came the first time, we had the talk. Then the second time, I didn't know she was doing it, but she kept on doing it. Then the third time, what happened was I was sleeping, and out of nowhere, the lights came on, and I opened up, and I looked around. I got scared because every single time she leaves me for someone else or purposely just leaves me just to hurt my feelings, I literally get scared, and I'm like, where's the love of my life? And she just keeps leaving. She's walking past the door, and I'm asking her, what are you doing? Why are you doing this to me all the time? And she doesn't say anything. She just says bye, and she has stuff with her, and I'm just like, okay. And the door shuts, and before I can say I love you or can you come back or something, she just leaves. And then and think about this. So after that happens, I go back to bed. I'm sleeping, right?
Sleeping.
2 hours later, not an hour, not 30 minutes, not even 5. Almost 2.5 hours later, probably 3, cops come to me and start telling me that I'm hurting her when I've never put my hands on her. And I have a video of her hitting me and assaulting me when all I do is open up my living space for her to live.
Oh, I
and for me
can't.
to try to love her. But everybody insists on hurting her body. Everybody insists on her saying it's an okay to get raped. My family taught me good ethics. And
Okay.
the point is, there was something really wrong with that situation. She's been to the mental hospital like 3 times. She tried to kill herself. She takes drugs. She takes medications. I think she's definitely schizophrenic. And all I'm saying is, if God is watching me right now, I swear to God, it was a wrong thing for her to do. So peace.
Okay. So here's what the court's going to do. Given that you have lack of, I'm sorry, did somebody just say something?
I just said I wanted nothing to do with that from the beginning. I had no idea.
Okay. So here's what the court's going to indicate. Based upon the defendant's lack of ties to community, not even to the county, to Wayne County, the fact that Mr.
I was looking for strip joints. I was looking for strip joints. I was just there looking for strip joints. That's what I was doing. Ma'am, what I was doing that day, ma'am,
Come back here. Stand right here. Shut your mouth.
what I was doing that day was I was literally just going to strip clubs. You can talk to them. And I was just going there having a good time. And then I got hungry. So I went to go look for food. It was Taco Bell. And because I have the gift cards. And when on my way to Taco Bell, I was like, I'd like to get high. So I sat down in the car, and this is the weird part is, why are people trying to, so this random guy says anyways, all I'm saying is I sat down, started to smoke a little bit, and then out of nowhere, cops come to my left and start talking to me, and I didn't even do anything wrong. And that's what I was doing. I was just looking for strip clubs because it was a good time. And you can talk to them. They know I was there.
Okay. So here's what the court's going to do. The court's going to indicate $10,000, 10% bond. In the event you post bond, these are the following bond conditions. Not to have any contact with the complaining witnesses in this matter: John Arraignment, Brendan Magdalene, Russell Skitch. You're also not to have any contact with any prosecution witnesses. No contact, sir, means no contact. A phone contact, text message, email, social media, third party, anything of the like. You're not to enter the premises at the victim's homes. You're not to possess or consume any alcohol or drugs that are not prescribed. You're required to have a GPS tether. You may work with proof shown. And that's going to be through the Wayne County Jail tether unit. And sir, if you were to test today, what would be detected in your system?
Just a little bit of marijuana.
Okay. Anything else?
I think nicotine, that should be out, I think.
Okay. All right, so that's the order of the court, and then we'll see you back
No.
next Thursday.
Thank you, Your Honor. Thank you, Your Honor.
So what's going on?
Thank you. All right, have a good day.
Okay, here we go. They gave you a little Valentine's Day love for that one. All right, here we go. George Washington.
We'll call the cases of Aaron Brown, 14W003896 and 07S824542.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Brown. And sir, can you unmute and state your name for the record, please?
Sir, could you please
Brown.
state your name for the record?
Aaron Brown.
Thank you.
Thank you. And on the case that is in the pretrial status, we are waiting for discovery, so we are asking for an adjournment.
No objection to the adjournment, Your Honor. This is a rather old ticket matter. If Mr. Brown wants to resolve it today, I would amend and add a count of a civil infraction of impeding traffic. He could admit that, and I would dismiss the misdemeanor.
Would you like to do that today, sir? That would be a civil infraction, so not a misdemeanor anymore. No points on your record and just a fine.
Okay. What am I doing about this GPS?
The GPS is on, I think, both of the cases. So, Your Honor, I would ask if it could be removed today as well.
So back on December the 27th, I did put him on because he appeared in custody, and these are 2014 and 2010, 7 cases. So Mr. Brown have been missing for so long.
I wasn't missing though. Y'all just kept giving me tickets, but not giving me tickets. I said y'all was gonna send them to me in the mail, and I just never received nothing. And y'all tell me I'll get pulled over. They say you got a warrant, but we're just gonna send you another ticket, and that's how they add it up like that.
Then we got a guy from San Francisco in the bottom. Oh man,
It just looked like I was running on y'all end.
Well, sir, they give you a ticket there on the spot. And they tell you that you have 10 days in which to address those tickets.
I never received the paper ticket from Washington County. They always tell me it's coming in the mail. I don't know why, but
Okay.
is it me, or when you're watching these court shows, the people that don't show up to court, they just simply say they just didn't get it in the mail? The mail system's pretty good. I mean, it's slow, but it's pretty good. When they don't show up, they say they never got it in the mail. I never got it. And a lot of the judges just let it happen. Am I wrong here? What is she gonna do?
So that is in the 2014 case, Mr. Barnett, is that correct?
Correct. Yeah, that's the 14W3896.
So, sir, on that particular case, the prosecutor is offering you to admit responsibility to an added count 2. of impeding traffic.
Impeding traffic. Do that mean I was driving?
So it's a reduction, sir. So it's, yes, so you would be saying that you were driving and impeding traffic would be what you were admitting to, but that would be a reduction from the misdemeanor.
But I wasn't driving. I had a cup of liquor. I was a passenger.
Okay, then you can plead to the
That's a
misdemeanor
scissor.
criminal case instead of a civil
The
infraction.
bling.
So y'all saying if I say I was driving, that'll be less?
Yes, sir. That's what she's saying.
Oh, okay.
One, it has $180 fine. The other one has a $325 fine, and it's a criminal matter that will be on your record.
Oof.
Oh, I'll get the difference now.
Thanks.
So you want to do that civil
Yeah.
infraction then?
Yes,
It
ma'am.
has no points either.
Okay. Thank you.
All right, you thank the prosecutor. I'm just trying to make sure you fully understand. I don't want you to
Cool.
make
I
a
love when
bad
you
choice
laugh.
here.
I
Okay.
love when Judge Washington
All
laughs.
right, so you accept responsibility for an impeding traffic on November the 7th, 2014 in the vicinity of East Clark Road and Prospect Road here in Ypsilanti Township, sir.
Yes.
All right. Fine is $180.
How long do I have to pay it?
I was about to ask you that. How
3 years,
how soon can you pay?
$6 a month.
I get like 20 days.
Can you pay that soon? I can set you up with a payment plan if you need that.
Oh, yeah, I can do that too. That'll be perfect.
How much can you pay per month?
75 cents.
$25.
Hey, oh,
$25 on what day?
Today's date. Like the 17th. Can I do the 17th?
$25 on the 17th of each month. Tether is removed. You have to go over this afternoon. You can get it removed.
I have to go down there tomorrow to get this other teller checked. Can I just do it tomorrow?
Yes, sir. And then I'll bring you back here on May 23rd to see if you're making your payments, okay?
Okay.
At 10. Now, what about this other case? What is this? The MIP show cause. These notes are terrible. Trying to follow it here. Oh, so how much is owed on this? He had 110, that's what it started with.
I believe it's 120 currently.
Okay. I'll just put you on a payment plan for both of those tickets, sir, okay?
Okay.
If you don't pay, you end up back in the same situation again. So make sure you pay.
I'm gonna pay it.
All right, so that's 120 and I'll put you on the same $25 per month. Okay,
Okay. And how do I go about paying?
this one is more challenging. I think you have to send it in the mail or show up here to pay it.
Okay.
Because it's a civil infraction, you can't pay it online.
Okay.
So May 23rd, 2023 at 10 a.m. Is when
Okay.
I see you again. If you're paying, you don't have to be here. If you're not paying, then I have to see you again. Okay?
Okay. The first ticket you said I could pay online.
oh, Mr.
None of
Brown.
them you can pay online. They're both civil infractions. So you have to
Okay.
put it in the mail. You can drop it in a mailbox, or you can show up here to the court and pay it.
You should
But I
literally-
don't think you can pay online. If you want to call out to the front desk and talk to them about that after 1 o'clock today, you can do that. Okay,
Okay.
Here's an envelope.
you're all set, sir.
Here's a
Good luck to you.
stamp. Put it in the mailbox. We're doomed as a society. We are doomed. All right, here we go. We are. I think I got more on this one too. Oh boy. Oh, Wyandotte never disappoints. Here we go. This is a bonus clip. I forgot about this.
No, I'm sorry, it's pretrial.
Pretrial.
Oh, baby.
And we are also here to resolve the original charge. By way of pretrial. So with respect to that, Your Honor, he would plead guilty to the failing to appear. He indicated he was not aware of the date.
I can't come up with a nickname for this guy. He's got a little Mr. Furley from Three's Company going on.
He indicated there was a period of time when he was in the hospital, did not receive a date. And when I read the register of actions, it appears that he was arraigned on the 9th of September of 2022. Originally, he was to appear for a pretrial on the 20th of September of that year. And there's a note in there that he was adjourned because of COVID, to 10/4. That was the date, I'm assuming, in our discussions, that he was not aware of. I also,
Counsel, I will indicate, I don't know how he wasn't aware of that because notice was mailed out. Was mailed out to him with the October 4th date after it was adjourned.
Your Honor, I'm only relaying the information I saw.
Right, yeah.
Yes. Your Honor, also, we have some discussion. Did this court place him on a tether?
Yes, GPS and alcohol tether.
Right, okay, and that's, we talked about that. He did obtain the tether, it's my understanding. And I just want to bring all that to the court's attention.
Okay, thank you. And so the court will indicate that
We're asking the warrant be set aside and we can address this issue.
court will recall the warrant. And as to the pretrial counsel.
Your Honor, I've discussed this matter with Mr. Parker. I've also discussed this with Ms. Taylor. It's my understanding that in return for a plea of guilty to open intoxicants, the much more serious charge of fraudulent schemes would be dismissed. It appears there was a dispute as to what Mr. Parker's first name was.
A dispute?
Well, he gave them the name Charles with the date of birth, and when they ran Charles, he had no ID on him.
So this guy's just walking around giving random names.
When I talked to him about that, he said, well, Charles is on my debit card. So
I remember this one, and I believe he has some other. Yes, he has. Alias.
Here we go.
don't believe at this point in time that there's any other outstanding warrants at this time for it. So I can't guarantee that.
Okay, well, as there was a matter under Charles.
So DiSanto's, there's two names that she's getting. She's two names. She can't figure out what name is which and what crime and what case and what's going on because he's got two different names going on, and for some reason they're legal. They're legal names that he's using. He explained.
What is your name?
Legal name is Charles Andrew Parker.
Okay, but when I asked your name just a few moments ago, didn't you tell the court Gerald?
Yeah, well, that's the name I am under Gerald. I was processed under that name. That's all I can say about it.
Sir, have you gone through the process to have your name legally changed?
No.
Okay, then you're Charles.
Correct.
If you want to have your friends call you Gerald?
No.
GG, whatever you want to be called.
Charles.
Your legal name is Charles.
Yes, ma'am. I don't know where that came from. It just came up on the paperwork that way. So, and a ticket.
But you also told this court a few moments ago your name is Gerald.
Well, that. Okay, in Hamtramck, I'm Charles. In here, and wind out, apparently I'm Gerald. I gotta go by what it says in the paperwork. I mean, if I go by Charles, someone's gonna contest it. So I don't know what to do.
Sir,
Yeah.
when somebody asks your name,
Okay.
what is your name?
My legal name is Charles Andrew Parker.
Okay, so whether you're in Hamtramck, Wyandotte, Detroit, anywhere else, what is your name?
Charles.
Okay, all right.
And Your Honor, that's the name he gave to the police. They then did some searching around and charged him under the name of Gerald. That seems to be the whole.
Well, because he has an alias listed.
Sounds like.
Apparently when he's in Hamtramck, he's one and.
I understand, Your Honor.
So, Mr. Parker,
Hamtramck's done.
Please.
Yes. Yes.
okay, please raise your right hand.
Okay.
You solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth.
Yes.
Okay, and so, sir, you heard the plea that your attorney indicated, correct?
Can you repeat that? There's noise in here. I didn't hear all of it.
You heard the plea that your attorney indicated, is that correct?
I believe so.
Okay, and you understand that according to the plea, you're going to be pleading, says you're going to be pleading guilty to count 2 open intoxicants.
Correct.
Okay, so as to that charge, how do you plead?
Guilty.
Okay, and you've gone over your rights with your attorney, correct?
Correct.
You understand those rights.
Yes, ma'am. Yeah.
You also understand by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
Okay.
Do you understand that?
Okay.
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 And you understand the possible penalty as a result of your plea?
Yes.
Knowing all that, you still want to continue with your plea?
I don't know.
You don't know?
I mean, I understand some of it, but I'm not an attorney, so.
I know that, but you had an opportunity to talk to your attorney, right? The one that's here on the
Okay,
screen?
let's just continue.
Let's just
Okay,
let's
so,
go. Let's keep
knowing
going.
all that, sir, you still want to continue with your plea?
Yes.
All right. And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and counsel, would you like to go to your client?
Thank you. Mr. Parker,
Yeah.
on September 9th of 2022, were you in the city of Wyandotte?
Yes.
And did there come a point in time where you came in contact with the Wyandotte police, and at that time you had open intoxicants? I believe it was a 24-ounce beer.
Yes.
Been satisfied, Your Honor.
All right, and you were out in public, correct?
Yeah, I think I was somewhere on North Line or some.
It's outside of a gas station, is that correct, sir?
Okay, yes. I mean,
All right. Okay.
it was a
That's
while.
fine. Okay, the court does find your plea as knowing, voluntary, and factually accurate. The court will accept your plea and dismiss count 1 per the plea agreement. And we'll schedule this matter for sentencing.
What is he doing?
On March 6th.
Okay.
Tuesday the 6th.
Yes,
Well,
at 9:20 a.m. And counsel as to bond.
Your Honor, as to bond, we'd ask that the original bond be reinstated. Necessary, obviously, an alcohol tether with a personal bond. Now, got this straightened out by names as well as by the appropriate proceedings. He asked for a personal bond and tether, he can hook up with the probation if possible today.
Well, okay, I am slightly confused. Mr. Parker, did you have a GPS alcohol tether on?
Yeah, I did. I just got it released, removed, yesterday.
This guy
Because
is
you're back in
burnt.
custody.
No, I guess because the time expired, but I was in recovery.
All right, good for you,
Okay,
dude.
where
Honor, ma'am?
were you, sir? Oh, yes.
He was at the treatment center, but he didn't show up for court and they had to bring him in on these warrants.
Yeah, something like that.
Okay, was he there?
Let me check and see if there's a report generated, but they brought him in yesterday about 4 p.m. yesterday.
Okay, do you know, what treatment he was in or which court?
We're checking right now, Your Honor. Stand by, please.
Okay, all right, thank you.
Your Honor, I discussed that with him, and he said he was in the treatment center.
Lake Ridge.
I'm assuming, and correct me if I'm wrong, that when you ordered the tether, it was to be tethered to a treatment center.
No, so I'm going to correct you. I did not.
I'm just guessing.
No, the only, you said correct you if you're wrong, so that's what I'm doing.
Okay.
So he had a 5,000, 10% bond GPS alcohol tether.
Okay.
I did not tether Mr. Parker to treatment.
And there obviously has not been any type of violations of the alcohol.
Your Honor, ma'am,
Yes.
he was at the treatment center, Lakeside Village, Lake Ridge Village, I'm sorry.
Okay.
But the defendant was tampering with the device, which triggered the alarm for the tether unit to go there. And then when they're investigating him, they realized he didn't show up for these 2 court dates.
Okay, so do you know which court sentenced him to Lake Ridge, or did he go on his own, or?
Stand by, Your Honor.
Yes.
Okay, thank you.
Now these 2 guys go next, and they have interesting stories too. So I'm just gonna keep it running.
Okay, so, well, I guess I'll indicate a $5,000, 10% bond. Well,
Would the court consider?
well, he was just tampering with tethers while he was in treatment. So, no, I'm not.
I don't know. It's my first tether this month.
My first tether this month, he said.
The court's going to indicate $5,000, 10% bond. So, what I'm going to indicate is, Deputy, is Mr. Parker able to be interviewed for a PSI right now? I'm not sure what your volume is.
Yes, ma'am, we can do it right now.
Okay, all right, thank you. Not possession of alcohol or drugs unless prescribed. And so, just if you can stick around, Mr. Parker, and I'll have probation Jim in.
I was going to ask, Your Honor, the chances of making it 10%, $5,000.
This guy's probably the chillest guy in jail.
Well, we don't have a docket next week on Monday, and then we have, and then it's 2.5.
I think he's still
2.5
drunk.
weeks.
Okay, that's fine.
So it's also needs probation needs time to prepare the
Oh,
PSI.
yes, no.
Okay.
Thank you.
Okay, thank you. Okay. All right. So Mr. Parker, as soon as probation logs in, I'm going to move the two of you into breakout room. I'll move you in a breakout room now, and then probation will join you. So that'll be breakout room 4.
Good luck, Mr. Parker.
Okay. And then find out jail. Let's unmute.
What's up, Tasha?
Okay. And so, okay, I have Mr. Dominique first. Is that fine?
Ready?
Mr. Kish, Your Honor.
Oh, Mr. Kish, okay. Mr. Kish first. All right, we're going on the record in the matter of the state of Michigan versus Stephen Kish, 23273. And Detective, your name please for the record.
Good morning, Your Honor. Christopher Shepke.
Police Department.
I'm sorry, we had miscommunication. Can you say that again, please, Detective?
Detective Carr, Wyandotte Police Department.
And good morning, Your Honor. Christopher Shepke appearing on behalf of my client. At this time, we consent to the matter being heard via Zoom.
All right, thank you. And so Detective, I'm going to have you please raise your right hand. Somebody swear from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on February 11th, 2023, about 8:40 p.m., officers observed the white Chevy Malibu westbound 3rd and Oak driving without headlights at a high rate of speed. Officers conducted a traffic stop and met with the driver and several occupants of that vehicle. A rear seat passenger of the Malibu, later identified as the victim, Christos Trochapolis, pardon my, explained that he was at Bishop Park, City Lot 1, where an unknown white male pointed a gun at him and threatened to shoot him, where they fled in that Malibu. The victim further explained that while he was at Bishop Park with friends, he attempted to meet with the unknown male in a blue Chevy Silverado, at which time the male, later identified as the defendant, Stephen Michael Kish, produced a black pistol from his waistband and threatened to shoot him. The victim added that he was at the park with friends who were familiar with the defendant, and he only attempted to meet him. Officers relayed the information to other assisting officers, where the defendant's identity and vehicle description was soon discovered via previous police contacts. A short time later, an off-duty Wyandotte police officer notified on-duty officers of a blue Chevy Silverado that was driving erratically and following him in his personal vehicle. The off-duty officer reported that he stopped at 7-Eleven near Chestnut and Biddle, where the suspect vehicle again followed. On-duty officers reported that they soon made contact with the defendant in the Chevy truck, and upon further investigations, officers reported they recovered a loaded Glock 40 caliber and loaded magazines from the glove box of the defendant's vehicle. The defendant was subsequently arrested for CCW and felonious assault, at which time he made unsolicited statements to officers about pulling a handgun from his waistband and pointing it near the victim.
All right, thank you. Upon examination of any witness, I find that the offense is charged or committed, there's probable cause to believe the defendant committed those offenses. And Mr. Kish, your name please for the record.
Stephen Kish.
Okay. And counsel, as to the arraignment.
As the arraignment will waive formal reading, my client stands mute.
All right, the court is going to waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. You had an opportunity to meet with an attorney today, correct?
What was that? I couldn't hear the last part.
You have had an opportunity to meet with an attorney today, correct?
Yes.
Okay. You also have the right, and the court's also assigned the order requesting court-appointed attorney for felony purposes. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Ma'am.
I'm sorry?
Yes, ma'am.
All right, the court's going to enter plea of not guilty on your behalf. Schedule this matter for probable cause conference on February 23rd at 8:40 a.m. And as to bond counsel, and then I'll give the judge an opportunity to respond.
Yes, Your Honor. My client is currently gainfully employed. He doesn't have any children. He doesn't have any probation matters on. He's not on probation or parole. It's my understanding he doesn't have any other holds. He indicates he's been in custody since Saturday. He will strictly comply to any and all provisions put in by this honorable court. He has respectfully requested consideration for a personal bond. Thank you, Judge.
Okay, the court will also note that there is a note that, Mr. Kish may have a retained counsel. However, the court's going to also note that there has not yet been an appearance filed. And so for those purposes, Mr. Kish has an attorney appointed to represent him. And so detective, as to bond.
Your Honor, regarding the bond conditions and considering the serious nature of the offense, I'm going to recommend a $10,000 cash, no showing bond, and obviously no contact with the victims or any witnesses in this case, as there seems to be quite a few reported witnesses in the matter.
Okay. Mr. Kish.
Yes.
I do recall you've been, it's been a couple of years since you've been here, sir. And you're not on probation or parole anywhere?
No, ma'am.
Are you out on bond in any other jurisdiction?
No, ma'am.
And where are you working?
RWS Recycle Waste Services.
He's got a good job. He's out swinging a gun around. I don't understand, why do these kids
And
do
then you're
that?
detected, what we detected in your system?
Just marijuana.
You have a valid medical marijuana card, sir?
No, ma'am, I let that expire. I've got one in my wallet, but that's expired.
Okay.
Thank you, Mark.
What happened to those 2019 matters from Riverview for destruction of property?
I handled all of it.
Okay.
What is she gonna do?
Given the nature of the charges and reviewing the report, and reviewing criminal history,
Simpson bomb.
court's going to indicate a $10,000 cash bond. In the event you post bond, sir, you're not to possess or consume any alcohol that or drugs that are not prescribed. If you do not have a valid medical marijuana card, that would include that. The court's going to indicate that you're not to have any contact with prosecution witnesses. You're also not to have any contact with Christos Shirkopoulos. That's phone contact, text message, email, social media, third party, anything of the like. Do you know who that individual is, sir?
No, the Saturday night was the first night that I've actually seen who it was or known who it was. He came up to my truck, asking me who I was, what my name was. I simply asked him nicely to get away from my truck. I don't know who you are. I don't know why you're trying to find out who I am.
Hold on. Sir. I don't want you to go into facts of the case.
Okay.
So I just wanted to know if you knew him.
No,
Okay, so perhaps you know of him through social media, I don't know, but you can't contact him through a third party, through social media, anything of the like. Court's going to also indicate not to possess or have access to any firearms and or any weapons. Other than the firearm that was confiscated as a result of the arrest, do you have any other firearms?
yes, ma'am, I do, and I will get rid of them. If that's what you guys want, I will gladly get rid of them.
Okay, well, here's what's going to happen. The Wyandotte PD is going to go to your home. Is that where those are located?
No, they are not. They're at
Where are
my
they
storage.
located, sir?
They're in my storage unit.
Okay,
I'm currently
so
moving
then-
out of my house.
I'm sorry?
I am currently moving out of my house.
The court's going to indicate that you're to surrender all firearms, ammunition, and weapons to the Wyandotte PD. So then, what will happen then, sir, is then if you post bond, you will have to have the police escort you to the location of the storage unit, and you will have to, you'll have to open it up. They'll retrieve the firearms and weapons and ammunition.
CR one.
Cash bond only. Anything else?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right, thank you. Have a good day. We're going to be off the record for a moment, just so I can, and then we're going, do you need to switch anybody out or are you all set? Okay.
All right, now we got
Okay,
Jordan
Mr.
jumped through,
McNally?
and he's got a story too. She had one after another. She had a story too.
Yes, ma'am.
Wondering why you're on Zoom and not in person. Just wondering why you're on Zoom and not in person.
I didn't know I was supposed to be in person today.
Yes, sir.
Yeah, okay.
Oh, I just been doing all Zoom, so I figured it was Zoom again. I didn't.
Because those are different days, sir.
Oh,
Where are you currently located, sir?
I can't really hear you.
Okay, where are you currently located?
I'm in Detroit working.
Okay, well, can you get a ride here?
I can probably get there before the end of the day. Yeah.
No, that's not going to work, sir. This court did not indicate that your court date was on Zoom today. And there are connection issues. We're not continuing on Zoom. So you need to make sure that you are here within the next 45 minutes.
You better bust your ass, get there, boy. Love looking at McNally's ear. Wonderful.
Your name, please.
Ernest Dominique.
Okay, we just saw you in here a little while ago, did we not?
Yes, ma'am, I had an issue with my dog.
All right, counsel, add to the arraignment.
As the arraignment, we're waiting for formal reading, my client stands mute.
The court will, and waive the formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for enter plea of not guilty, schedule this matter for pre-trial on February 23rd. And as to bond counsel.
Your Honor, my
Sorry,
client,
That'll be at 9:45, sorry.
yes, Your Honor, my client was very polite and contrite through our interview. He indicated he will appear timely at all future court dates. He's apologetic for finding himself in this predicament, but going forward, Judge, he will strictly comply with the terms and conditions ordered by this court. Furthermore, his place of residence is not where the complainant resides, so there should be no conflict there. I would be asking for consideration for a personal bond. Thank you, Judge.
Mr. Dominique,
Yes, ma'am.
your address is accurate?
Yes, ma'am, I own that home. That's my home.
And are you still on probation or
I'm not
are
on
you on
probation.
probation for anyone?
Oh, no, ma'am.
We're jumping to Bryant. The feed got cut off on that one.
11059.
Bryant time.
08301. The people of the state of Michigan versus Adante Jones. Defendant is charged with 1 count of assault aggravated, and today is the date set for a pretrial conference. Appearances, please.
Bryant time.
Your Honors,
Oh, I'm sorry. It's review. Thank you, counsel.
Jessica Scheib on behalf of Mr. Jones. Mr. Jones, please state your full name for the record.
Dante Kennard Jones.
Thank you, Mr. Jones. Today is the day set for review. Now, let me just get straight to it. Straight, no chaser. How many times we gonna let Mr. Jones show up for probation, not show back up, show up for probation, not show back up? Do we want probation or not? What's going on?
So, Your Honor, according to Mr. Jones, he's completed probation.
He didn't complete it if the judge didn't say he didn't complete it. So he didn't show up for his final review. And the case has been going on so long. On the first 2 pages, we don't even have information that, of who put it in, because it's from the old system. It was from the old system. So then he came back in front of me in 2021. We held a review, and then we did. I placed him back on probation, and then he was supposed to come back. Let's see, he came back in May. Well, no, he was supposed to come back in May. So let me say, he was supposed to come back in May, and he didn't. So then I gave him a court date in June. Then he at 9:35. So then in June, he didn't come back again. That's 2 court dates he missed after I reinstated his probation. 2 court dates he missed after I reinstated his probation. So then when he didn't come in June, that's when I issued the warrant for his arrest. That was June 2021. Then he got the warrant set aside and came in August 2021. And then looks like we adjourned it till September 2021. And he was supposed, and I adjourned it so he could complete the terms and conditions of his probation. He was supposed to come November 8th of 2021, November 8th, 2021. And guess what happened on November 8th, 2021? Mr. Jones failed to appear, and I issued another warrant for his arrest. That's where we are. When did he complete the terms and conditions of his probation?
Oh, that's
When?
Oh,
I'm
don't
ready.
give her a
Tell
stink
me.
face.
but Miss Bryant,
No, it's not Miss Bryant. My name.
Judge Bryant, I'm sorry.
Mhm.
I'm sorry, but as far as the ticket I got that out the way.
It's no ticket. This is the misdemeanor courtroom. There was no ticket issued. There was a complaint issued by the Wayne County prosecutor. There's no tickets involved in a
Well, not the ticket, I mean, like a fine or something, because I believe it
no,
was.
sir. Let me help you. You were charged with a 1-year misdemeanor, aggravated assault. That is a 1-year misdemeanor. It is punishable by up to 365 days in the Wayne County Jail, up to 5 years probation, up to $1,000 in fines plus costs. It's a 1-year misdemeanor. We're not talking about a ticket. We're not talking about a traffic case. We're not talking about if I just pay some money. Not only were you ordered to pay money, but you were also ordered to complete 12 weeks of anger management. You were ordered to submit to random urinalysis, no drugs or marijuana. You were ordered to, what else is on here? So the reason I know, because I resentenced him. That's what that says. Defendant resentenced or something. I reinstated his probation, really. Yeah, random urinalysis, anger management classes, and he was scheduled for review. So I can tell by his language, he didn't do the probation because he's talking about paying a fine. Yeah, he was ordered to pay a $200 fine, some cost $65, $345 miscellaneous. I don't understand, the original sentence, whatever it was, but it only added up to $610. That was something that's not something I did. And then I could tell that and then back in 2012, he had a violation of probation hearing. He's not done the probation. He has not done the probation. I'm sure if I call Mr. Sciotti right now, he's going to say he's not seen Mr. Jones. I'm sure that's what's going to happen. But I can call him if you want me to. Mr. Jones, have you been seeing Mr. Sciotti, your probation officer?
Well, it was supposed to be a non-reporting, but I did.
It's nothing that I said non-reporting, because I'm sure when I resentenced you back on January 25th, 2021 for an aggravated assault case, and I'm certain that I did not say non-reporting. There's nothing in here that says non-reporting, and Mr. Sciotti is your probation officer. And I can call him. I can call him and see if he completed the anger management classes. Did you complete the anger management classes?
Oh, ma'am, I had, I believe, 6 more to do.
Okay.
And on November the 8th was supposed to be the review. And when I called into the Zoom, I was kicked out. And that's how I ended up getting a warrant, because I called the clerk after I was kicked out, and she told me that she had to issue a warrant for it.
No, first of all, my clerk don't issue warrants. So that's number one. Only person on this Zoom that's issuing warrants is me. Number two, let me be clear that it doesn't happen like that. If you came into the Zoom and got kicked out that day, that's not what we would have done. We don't issue warrants because a person showed up on Zoom. So let's talk about what really happened. So if you came and called my clerk, it was after court was over.
Yes.
And I had already issued a warrant for your arrest. I didn't issue a warrant to a person who popped in the Zoom. And then who you should be calling is the lawyer and not the clerk, saying, hey, I got kicked out of Zoom. What should I do? Because they would have told you, well, if you can't get back in the Zoom, come down to the court because it's open to individuals who have business with the court. So here's the thing, Mr. Jones, as I indicated, this is from 2011. I was nowhere near this docket on 2011. I was on some other docket, man, and some other business. However, either we're going to do this probation or we're not, but I'm not going to keep doing cases from 10 years ago, 11 years ago, 12 years ago.
That's what I'm
saying.
That's
not what you're saying, because if you were serious about it, you would have completed the anger management, and we would be here even if you didn't come. you would be finished with what you had to do. Getting kicked off of Zoom in 2021 has nothing to do with the reason that you're just showing back up in 2023. It doesn't. So let's say what it is, the truth of what it is. Let's not live in a fantasy world. Now,
You're right.
You want to
I
do
didn't
this
take the
probation
class.
or not?
I do, because I don't need this hanging over my head for another 12 years.
I think I would agree. I would agree. So here's what we're gonna do. I'm gonna reinstate the probation for the last time. Because Mr. Jones, I definitely believe in another chance. I definitely believe people deserve more than, some people say we'll give you a second chance. Sometimes people, need more than a second chance. But Mr. Jones, this is about your third or fourth chance to finish the probation on an aggravated assault. An aggravated assault means that an individual was assaulted and it resulted in an injury of some sort. And you should have had this probation finished by 2012.
Yes.
That's been a long time. So I'm going to reinstate the probation for the last time. Hear me when I say, and I need the record to reflect. So if he come back some 2 years from now and I'm still on this docket, I'm going to see that I said reinstated for the last time. I want that in the register of action. You need to, now here's the thing about the anger management. You've been gone too long. It's like going to college and then taking half of the class, not finishing the other half. When you go back, they're gonna make you start over. So Mr. Rice isn't gonna let you just drop in to the 7th class.
See,
I'm sure he's gonna make you start over. But you need to do the anger management. That's gonna be between you and Mr. Rice. I don't have any control over his classes. Miss Seelman, do you have the actual file?
Let me check. I'm checking right now, Judge.
Okay, because what I'm interested in seeing is if who sentenced him? If either there's an order from me when I resentenced him, or if there's an original. And I'm looking at the register, so it looks like, well, and this
I have
is
original. Wait, it's not original. This is from you, from January 25th when you sentenced him.
okay. So I sent him. And it doesn't say non-reporting, does it?
No, it does not say.
Does it say how many anger management classes I ordered him to do?
Yeah. No, it just says anger management classes. Don't state how many.
Well, I'm sure I said 12 on the record. That's what I normally say. How many did you do?
I did 2 for a fact. So that's why I thought it was 8 left that I had to do.
Oh, well, maybe I did say 10. Okay, I don't know. Well, I'll say 10. Let's say 10 now. And then do you take any drugs or anything?
No, I do not.
Do you smoke weed?
No, ma'am, I do not.
Do you eat weed?
No, I do not.
Look, I have to be specific now. Do you eat the edibles? All right, so this is what I'm gonna
Judge,
do.
I just wanted to say I'm a truck driver, so that's why I thought it was a non-reporting, because I don't
Reporting doesn't have to be in person, Mr. Jones. You can report on the phone, you can report now. At the time, oh no, in 2021, that was after COVID. So you can report on the phone, you can report on Zoom, you can, just like you're doing now. It's not necessarily in person. I'm not going to stop you from being a truck driver. And even the anger management classes are on Zoom. They're on Zoom. So I don't, if at all possible, I don't want to interfere with an individual's ability to make a living. Even though you have this case, but please understand that ultimately, if you don't do the case, like I said, it's a 1-year misdemeanor. That means you could be sent to the Wayne County Jail for up to 1 year. We don't want that, Mr. Jones, but you're gonna have to go ahead and do these classes. You did pay the money. So let me just be clear. Whatever the money was, there's now a zero balance. Okay, so you did pay the money. I need you to do the classes, okay?
Okay.
I'm gonna reinstate for, he said he need 10, that's 10 weeks, that's at least 2 months. So let's just go ahead and reinstate for 90 days and see if you can get it done in 90 days, okay?
Okay, because to my understanding, I think his classes is every Tuesday.
Yeah, something like that, a Tuesday or a Wednesday, something like that. So this is February, March, April, May. Let's come back May. Oh, and my May, it's kind of shake. Oh, no, I can fit you in on May 15th. Let's put it on May 15th.
I think that's fair enough.
All right. Thank you for, even though I was fussing at you for thinking it was fair.
She's always nice.
All
in
right,
the
May
end. That's why I love
15th
Brian.
at 10 o'clock. If you have completed those classes, I'm going to discharge you from probation and you can get this out of your life, okay?
She reminds me of like
How old are you,
that
Mr.
aunt
Jones?
that is real tough on you, like your
32 in
second
October.
mom, but she
And so
always
back
like
in
she'll always spoil you, even though she's a pain in the ass.
2012,
I had probably just
It's
turned
like that
21.
favorite aunt that's tough on you and loves
Mhm.
you, but you know she's
All
always
right.
gonna
Well,
she's
we'll
always
see
gonna
how the
take your
prosecutor
side
feels when you come
against your
back, or
mother.
you might could ask them for Haida. All right. You're all set. Anything else,
No, man.
Miss Scheid?
All right, so this is my second live. I'm throwing
Nothing
in
further.
a classic.
All right, we're
I've
all
only
set.
been
Have
around
a
for
great
2
day.
weeks, guys,
Stay
but I already
safe.
got a classic.
Thank you, you too.
In the comments, people have been asking me they want to put this in the live,
Anyone
so I
else
got to
you're
put this in the live. Here we go.
That need to be addressed to me or sent to you first, and then we can both be on the same page.
Yes, Judge.
Okay, so for the record, this is position 41 on my calendar, state of Georgia versus Stephanie Howell. And Ms. Howell is charged in warrant number 2022 CW 54744 with committing the offense of aggravated assault. Discharged in warrant number 2022 CW 54745 with committing the offense of family violence battery. She's also charged in warrant number 22 CW 54746. That doesn't list on my calendar what the charge is.
It's cruelty to children in the first degree.
And it's so
Okay.
serious.
Mhm.
This is so
Cruelty to
serious.
children first degree, which is a felony. She's charged with warrant number 2022 CW 54747 with committing the offense of false imprisonment. And she's charged in warrant number 2022 CW 54748 with committing the offense of aggravated battery. At the jail, could we bring up Miss Stephanie Howell? And as I understand it,
Yes, sir. I'll bring it up right now.
Thank you. As I understand, Ms. Freeman, we're dealing with issue of bond.
That's correct, Judge. Again, I've already forwarded Attorney Banks the waiver. And so as soon as he sends that back to me, I'll forward it to Your Honor.
Okay.
I will get that executed in short order, Judge. I'm waiting for it to print off.
No, and that's fine. And Mr. Banks, because this is an issue dealing with bond, you're going to be the first to go for it as it relates to your request for bond for your client.
Okay.
I'm sorry.
I think she's up, Judge, and whenever the court.
So, Mistress of Fun's asking who and where this is from. This is one of my favorites, Judge Brad Gardner. People who've been following me since the beginning know that I always throw Judge Brad Gardner in, and he's out of Georgia. And this is one of the lawyers that's working with him, and we called this one Peekaboo. So this is Judge Gardner from Georgia.
Yes, I'm ready. Miss Howell, can you hear me?
Yes, sir, I can.
So, ma'am, we're here dealing right now with the issue of bond. There's already been a matter that has been worked out between your lawyer and the state as it relates to the charges in the case moving forward. Now we're dealing with the issue of what bond amount, if any, is appropriate in your case. Okay, ma'am?
Yes, sir.
Okay. Mr. Banks.
Good morning, Judge Gabe Banks on behalf of Stephanie Howe. It's good to see you, Your Honor. Before I address the 4 Ayala factors, I would just say as a threshold matter that this is not a rebuttable presumption case whereby there's a presumption that no condition or combination of conditions could satisfy that she would return to court and or that she's a danger to the community. I would also say that just generally in 1966, the Bail Reform Act was passed. It has been amended on many occasions, and it has been cited approvingly by the Supreme Court of the United States, and it has a liberal policy.
Okay, so let's do a little throwback.
You
Here we go.
notify your attorney that you were.
Here we go. So this was today. This was out of Judge Webster's court, 13th District out of Kansas. And this one is, if you see the girl all the way to the right, there was one of the reasons why I started watching court shows was the one where they actually sent the sheriffs to her house to pick her up while they were on the Zoom call. Well, this is her. This is the update. This is her. They actually caught her. So now Missy, Miss Gillette and Webster are going to start seeing what bond is going to be the right amount because they want to keep her where they have her. And then after that, there's something where they caught something. They caught a bunch of kids in a household full of drugs. I don't know if it was a search warrant or they broke up a party. I wasn't clear on that, but and then there's just all the kids are on the docket and Webster's just like yelling at them, and it's just great. So let's roll.
Going to be back in court and that you're going to have the first appearance following your return. I don't know if Mr. Ambrose has had time to reach you yet or not. Have you heard from Mr. Ambrose? Could we get her volume turned up at the jail? I'm not hearing you. Still not hearing you.
Can't use mute either. Technical difficulties, gotta love it.
Okay.
There we go.
I called him before I turned myself in.
All right, and so
Let
he
him know I was in Kansas.
I'm sorry.
I called him before I turned myself in.
Okay. Well, let's see. We can either set this for an evidentiary preliminary hearing or set it for a preliminary hearing control. Ms. Gillette, appearing for the state, do you have a preference?
Hello, Miss Anna.
No, Judge, I don't really have a preference one way or the other. Her attorney on this matter was Mr. Ambrose at one time.
And he still is her attorney. And we certainly should have the drug lab tests back, don't we?
Her and the co-defendant. Her co-defendant, I believe he pled not too long ago.
Remind me what his name was, please.
I believe it was Mr. Bird.
Does that sound right, Miss Green? You and Mr. Bird were together?
Vehicle, yeah.
I'm sorry, can you speak up or get closer to the microphone?
In the vehicle, yeah.
Okay. You still have contact with him?
No.
Okay, you're not supposed to be, but just checking.
Yeah.
Okay, well, Ms. Gillette, again, you have lab report or lab results back.
I thought we did because Mr. Bird just pled on them.
You think we need to set this for evidentiary hearing or set it for PHC? I don't want to lose track of her again. Well, so you don't have a preference, Ms. Gillette?
I do not. I think Mr. Ambrose would probably like a PHC since he hasn't talked to his client in months and she's just now back.
Well, she said she talked to him before she turned herself in here recently. Missy, do you have any word on that? Did you hear from Mr. Ambrose yet?
I have not heard from him, so I was going to suggest that we put it on the PHC docket on March 3rd when I know he's going to be here, and then if they decide they want an evidentiary hearing, maybe we can get that set up.
All right. We'll set it for preliminary hearing control March 3rd. Now, if he calls us and lets us know he wants an evidentiary hearing before then, he can do that. But I am not comfortable turning you loose again, Miss Green. I credit you for your mother turning you back in. She probably didn't want to lose that money she put out. But, you know, you could always get in a state of mind that you want to run, and then there you go again. So, between the stories you've told me and the absences you've had, I have you on a no bond hold now. Mr. Ambrose might argue that you're entitled to some type of bond, but I'd have to set it high enough that I know you're not going to take off again. Are you wanting to be heard on the bond now, or do you want to wait and talk to Mr. Ambrose?
I would like to discuss bond.
Okay, you're going to have to get closer to that microphone and tell me what you want me to consider.
I mean, I would like to consider an OR bond with ankle monitor.
That's not going to happen, Miss Green. Can't trust you on that.
You ain't going anywhere.
Or a 15,000 or 1,500 cash only bond.
Listen to her. She's wheeling and dealing.
1,500 cash only bonds?
A 1,500 cash only bond.
That's
Yeah.
what, double what your mother paid the first time?
No, it is like a quarter of it. Like 1,500.
August 23rd, 2022, you posted a 7,500 cash bond, or your mother did, right?
Yeah.
And you're wanting me to reduce that bond now that she's brought you back to 1,500?
Well, when I got booked in, they told me my bond, I didn't have it. When I turned myself in, they said my bond was at 15,000. They didn't tell me I was on a no bond hold. This is new to me.
Well, there's a difference between 15,000 and at one time it was set at 15,000. But then
I only
missed a couple court dates. And after you told me you were in Alaska and you turned out to be in Colorado, and we were going to have to extradite you back, I said no bond, hold until you see me. So that's why you weren't given a bond when you checked in. But now I think I heard you say you didn't, that not 15,000 as it once was, but 1,500. Did I hear that right or not?
Yeah, it's only because I'm not from this state, and so the bondsman wouldn't
He wouldn't take a risk for you?
Yeah, and I bonded out in Colorado, and I have a bondsman in Colorado where I have a place to stay and a job. I had a job on that last court day. I was working at Wendy's, but then you wanted me to turn myself in.
But you didn't turn yourself in, did you? Not in Colorado like I told you to.
No.
And then your
But I
mom
did-
somehow got you in the car and drove you back here to Kansas? Is that right?
Yeah.
Did she do that so that she could get her bond money back?
No. I was in Colorado and she's like, how about this? You know, I was sitting in Colorado jail since the 14th of January. And then I got out and then I turned myself in within the 7 days. And she was like, while I was in jail in El Paso County, she was like, how about this? I'll come see you and we can go to Kansas together. It was more of like, she wanted to see me more than like she wanted to turn me in. It was both of our decisions because I don't want to run. I don't want to have a warrant. I want to start my life. I want to have a job, you know? And when I got that job at Wendy's, I can go back there, you know, and so
Okay.
I just want to get this over with.
Let's see what Ms. Gillette has to say about your bond. Ms. Gillette, any recommendations from the state?
Judge, we were in the process of obtaining a governor's warrant for Ms. Green. So I want no less than $50,000. And, you know, I think an EMD is a good idea because she takes off. You know, she stayed in Colorado for a long time, lied to us, had to send Colorado officers after her. She skipped out on her extradition bond and warrant out there, and missed one of her hearings there in Colorado. So it's been real hard to get her back from another state. Frankly, I don't want her in another state because I'm afraid I'm going to have to send another warrant after her. And she has ties to Alaska. If she ends up there, we have to skip over another country to bring her back. I'm sure one of the guys would like to go elk hunting while they're up there, but that's not a practical thing for the rest of us to have to do and very expensive. So I think that a significant bond, maybe even 100,000, so that she's somewhere else. I mean, I just don't have any trust that she's coming to court.
Well, she's supposed to be a citizen of Alaska, isn't she? Isn't that truly her home?
I don't. Gee, I just want to be able to get through the case before she takes off again.
Okay. And how did she get out of custody when we were doing the governor's warrant on her? How did she, I mean, as I recall, I witnessed your signature. You gave me an affidavit. Isn't this the case you did all of that on just a couple of weeks ago or less?
She had an extradition bond in Colorado. They gave her an extradition bond and she was out on an extradition bond and skipped out on their court as well. And she didn't want to be extradited back to Kansas. So I was in the process of getting a governor's warrant for her to bring her back to Kansas.
Well, and I thought I had a no bond hold on her.
You did, Your Honor, but evidently Colorado, even after this going through 2 times, does not honor your bond. They give them extradition bonds with the condition she turns herself in here in 7 days or goes back to their jail within that time frame.
The first time we tried that, she didn't go back to their court.
Exactly, Your Honor.
And then she showed up here by Zoom court, but not in custody. It's been one long convoluted mess trying to keep track of her. Thank you, Under Sheriff Cox, for that information. So I'm going to set your bond at 100,000. Now you and your attorney can talk, and if you do make that bond, it will require an electronic monitoring device. And you're not, as a condition of your bond, allowed to leave the state of Kansas. But I even at 100,000, I'm leery, Ms. Green, because you've demonstrated to me that you have an unusual ability to get out of jail and get around and get folks to help you so that you're not in court. Your mother had no trouble coming up with the $7,500 cash bond. I can't remember what southern state she came back from a funeral to post that bond for you. So I'm just really concerned about keeping track of you. And I think that's what I'm going to set that at, to hopefully keep you in place. But once you and your attorney talk again, maybe we can revisit that bond issue. But at least in jail, I know where you are. I know you're being fed. Don't have to worry. You know, I've worried even about, is there a chance you've been trafficked by people, misused?
It's a good question by Webster.
Is that any concern that I justifiably should have?
You may feel for her a little bit, you know, like she's a pain in the ass and a manipulator, but you never know.
And remind me again what the tattoo on your forehead says.
It says Calypsia.
Spell that for me. Calypsia.
Yeah, it's Kalopsia.
Oh, you went way too fast. K-A what?
Lopsia.
Calypsia. And what does that mean?
It's the delusion of seeing things more beautiful than they really are.
And where did you come up with that?
I like words.
Think about now.
I like looking at different words. Like
I like words.
Okay.
Like words.
It doesn't represent someone's name or
no, it's just a
authority
word.
or anything
It's
like
Greek.
that. It's Greek.
Yeah.
Okay. Well, I think I've told you I've seen forehead writing like that before. I don't know if it's the same word, but
no.
But not only do I worry about what you've done to violate society's rules, but I also am concerned about you yourself and what kind of danger you pose to yourself as well as to others, the way you disappear. And so also, if you make bond, I want you to do a bond review every week. So you'll have to check in with one of our bond supervisors, and you'll be subject to random UAs. Make sure you're not using any illegal substances. Missy, do you want to let the jail know who her supervisor will be?
I think she had one from
Oh, I think she did too. It was
before.
And she didn't keep the
I
appointment.
love
so
Missy
that's
and Webster.
kind of worth
They're
it.
like Batman and Robin of the 13th.
So I'll have to
district.
check out and see who it was.
Missy's on it all the time.
Okay, Miss Green, if you get out, don't keep putting us through this, because it's going to get harder and harder for you once we do keep up with it. Let's get this resolved.
Like I said, that's all I want is to get this resolved and start my life.
Okay, all right. Well, and Missy, when did you set this for? March 3rd at what time? 1:30?
Yes.
Okay. Anything else we need to address on this matter, Miss Gillette?
I don't believe so, Your Honor. I'll get a hold of Mr. Ambrose.
Thank you. I appreciate that. Make sure he has his lab reports and everything he needs. Anything you want to address, Miss Green, before I let you go back to the custody of the sheriff there?
No.
I'm sorry, I didn't hear you.
No, thank you.
All right, you're welcome. You may go at this time.
Okay, so now we got in the Hess house. It must have been like this big bus.
And who all is in custody? Are they at the bottom of the list, Missy?
Yes, they are.
Who do they start with?
Andrews.
Andrews, okay. Let's go on the record then. In 2023 CR 22, State of Kansas versus Blaine Michael Baker. The state is appearing by and through Jill Gillette, County Attorney. Blaine Michael Baker, where are you?
Bye, Kerry.
There you are, sir. Thank you. Mr. Baker, in person and pro se. Mr. Baker, you're here on one count of possession of marijuana dating back to January 9th of 2023. Under Kansas law, this is a Class B non-person misdemeanor. If convicted, the maximum fine could be $1,000 and the maximum jail could be 6 months. Do you have any questions about any of this so far?
No, Your Honor.
You do have the right to hire any attorney of your choice, apply for court appointed, or represent yourself. You have the right to plead not guilty and set this for trial, or to plead guilty and proceed with sentencing. You also could plead no contest, which neither admits nor denies the charges, but you'd still be found guilty. Or Ms. Gillette, does he look like a possible diversion candidate? Have you ever had a diversion before, Mr. Baker? Do you know what that is?
No, I've never had a diversion, Your Honor.
Okay, have you heard about it, where it's a contract between you and the county attorney? And if you pay your fine costs, maybe do a evaluation to see if you need treatment, they might be willing to dismiss the charges. Have you ever heard of anything like that?
Yes, Your Honor, I have.
Okay. Ms. Gillette, what do you think? Does he look like someone who ought to apply and see if he qualifies?
It's possible he could maybe qualify.
All right. Do you want to have some time to check with Ms. Gillette's office and see if you qualify?
No, thank you, Your Honor.
All right. How would you like to proceed then?
I would like to plead not guilty, and I would like a court-appointed attorney.
Okay, then we will enter a plea of not guilty. We will see if you qualify for a court-appointed attorney. Are you employed?
No.
Can you bring your audio and video back? Thank you, please. You're not employed. How old are you?
I am 21 years old.
Okay, 21, no job. Do you go to school?
No, Your Honor.
What do you do with your time?
Thanks, Willie.
Right now, I'm in between jobs, Your Honor.
So how long have you been in between jobs?
It's been about a month and a half, I'd say, Your Honor.
All right, what was your last job?
It's like
I was working at Fanistil Meats in Emporia, Kansas.
Okay. And why did you leave Fanistil?
I was fired.
Shocker.
Have you been looking for work since then?
Yes, I have.
Where all have you applied?
I've applied at Casey's, and they got back to me with an interview.
All right.
Okay, when's your interview?
Well, I had it yesterday, and they haven't told me if I had the job yet.
Okay,
Everybody
else
who's
have you
at court
applied?
has a job lined up with either the day before or
That's
the next day.
the only place I've applied at, because they got back to me fairly quickly.
Okay, so in a month and a half, you've applied at Casey's and that's it?
Yes.
Do you have any health concerns?
No, Your Honor.
Who do you keep looking at for advice there?
Oh, I'm just looking at my father.
Okay, so your father's there with you?
Yes, Your Honor.
Is he the one supporting you for the last month and a half?
Yes, he is.
He's okay with you not working?
He knows that I'm trying to get a job and I'm working towards. And I'm also getting clean. That's how I'm able to live here.
Okay, so he is okay with you not working?
For the time being, yes.
Okay. And you are looking for work, but you've applied at one job in a month and a half?
Yes.
Okay. And you're trying to get clean, what does that mean?
I have stopped all usage of marijuana.
How long have you been clean?
About a month.
I ordered you to come in today and give me a UA or hair follicle, would you be clean?
No.
I'm not entirely sure, Your Honor.
Just smoked about 10 minutes before court.
Well, you're on bond, right?
Yes, Your Honor.
You've made a bond,
Yes, I have.
then you were ordered not to break the law on bond, which means don't use drugs, right?
Correct.
Webster's pulling her best Dare Bear impression.
What's your highest level of education completed?
4th grade.
High school, Your Honor.
You did graduate from high school?
Yes.
Which high school?
Eureka High School.
So are you a local Eureka person?
Yes, I am.
I will appoint Attorney Shannon Cooper to represent you. You must call Ms. Cooper and give her all
You
your
got it right, huh,
contact
Joey?
information. Are you ready for her number?
Judge, there might be a conflict for Miss Cooper on this matter due to the co-defendant situation.
Who's the co-defendant, if you recall the name?
This individual was in the Hess bust at the Hess house.
The Hess house.
So we'll have to go through
Eureka
the list
Hess
of all
house.
of the different attorneys.
Okay. Is he a diversion candidate?
He would possibly be a diversion candidate.
Are you the one that told me you didn't want to apply for diversion? You wanted a trial and an attorney? Is that you? Okay. I will court appoint an attorney. I do not know who it will be. Call back here Friday and my assistant Missy will tell you who your attorney is. You would have absolutely no contact with any of the people involved in that Hess house or search warrant.
Yes, Your Honor.
Miss Gillette, if I order him for bond supervision, do you know if they can UA him today?
I don't know, Judge. It'd be up to Carrie or Jessica.
All right, if Jessica or Carrie are available and could answer that question, I know you're swamped with other responsibilities. Okay. When's his next court date? We'll put him on a misdemeanor control date.
March 7th at 3:30.
March 7 at 3:30. You must be back here with your attorney on Zoom, March 7th at 3:30. You've made bond, I believe it was what, a $500 bond?
Yes.
Billy!
But you're just, where are you going to treatment?
I'm not being treated.
So
Really?
your dad is letting you at 21 live in his home, no job, no school, and only your word that you're not taking dope after you've been arrested in a house where the search warrant was done for drugs and other marijuana, not only marijuana, but a lot of other drugs.
Yes, Your Honor.
That Hess house was quite a party.
What's your dad's name?
Andrew Baker.
Okay. Anything else we need to take up, Ms. Gillette, on this case?
And not at this time.
Do you know?
Judge, I
Yes,
spoke with the CSOs. They're going to have to ask their supervisor because if they're not actually on probation, just the bond supervision.
okay, if
they
they're
can
just
do
on
UAs,
bond,
so
okay. Well,
remember conversation that you had with him about the bond
I do
supervision?
remember, but this is one
Okay.
situation where I am concerned. But, okay, no bond supervision. But if I find that you are violating that bond by hanging out at that house or with those people or anything of that sort, if I have any reason to haul you in here on a bond
Welcome to the party.
revocation, I will do it, and you can sit there until this case resolves itself, because I'm not nearly as trusting of you as your dad is. In fact, I'm concerned that your dad does trust you as much as he does. Why that is. I hope it's for good reasons. All right, Mr. Baker, call back Friday and find out who your attorney is. I'm also concerned that you can't tell me for sure after a month and a half that you'd be clean today.
Yeah.
Well, Your Honor, I say that because THC isn't always as simple as in a certain amount of time, because depending on a person's usage and how much they use can affect how long it takes for them to pass a UA.
Have you been on probation before for drugs?
No, I have not.
How do you have this knowledge? You seem awfully knowledgeable for a first time charge.
I love Webster. He's so sassy. He's so
Just
sassy.
people I've talked to before. They've been happy to shed a lot of knowledge for me.
And they have this knowledge. See, again, I'm concerned about who you hang out with, that they have all this knowledge about how long your urine tests for marijuana. Has your dad ever been on probation for possession of marijuana?
No, he has not.
Okay. Well, it's too bad that I can't just order you to be supervised on bond and get those tests to make sure you're not violating the law and you're staying clean, but there's a lot of too bads in this and other cases, so talk to your attorney and we'll go from there, March 7th.
Your Honor.
Yes?
What number do I need to call?
Whoa, 620-583-8153, isn't it, Missy? No, 8155.
8155.
Yes. But if I find out that I can get you on bond supervision and I can get you tested, I could give you a call at any moment and require that. So you better make sure you're clean. And I do have a lot of history on how long these things stay in your body.
Get him,
So
Webster.
keep that in mind.
All right, Your Honor.
All right.
Webster's
Free
getting
to
playing
go at
down the
this
low
time.
with these kids.
Thank
Well,
you.
you're welcome. We'll now be on the record in 2023 CR 21 State versus Cody Michael Clater. County Attorney Jill Gillette appearing for the state. Cody Clater, where are you?
I'm here, Your Honor. I am at my home.
Can you turn your camera so it's right, your right side up?
Yeah.
How old are you, Cody Clater?
I am 19 years old, Your Honor.
Sup, dude?
And were you one of them in the Hess household when they did the search warrant?
Yes, I was, Your Honor.
So your buddy,
Dude, bro.
Yes, Your Honor.
were you one of the buddies telling him all about how long marijuana stays in the system and UAs and all that?
No, I am not, Your Honor.
With these kids.
You're on a $500 bond as well.
Yes, Your Honor.
You know you're not supposed to be using any illegal substance.
Yes, Your Honor.
Are you going to be applying for an attorney?
Yes, I'm going to be applying for a court-appointed attorney.
And how old are you? You're 19. Are you in school?
Yes, I am in school, Your Honor. I am in the 12th grade.
You're a senior at Eureka.
Yep, at Eureka Junior Senior High School.
Expect to graduate on time in May.
I am expecting that, yes.
Okay, any chance it won't happen?
I'm working on making up some classes from previous years, so I'm trying my hardest. I'm staying dedicated and I'm trying to get the classes done, but there is still a chance that I could not get them finished. But I'm ahead right now on my work. I've made sure to get ahead on my work. So I'm hoping that yes, I can graduate and walk by graduation time.
So you don't have a job?
Currently I do not have a job. I have applied at the nursing home and they have told me that I can be hired. They just gotta wait for a position to open up for me. I've also been working on putting in applications at the Dollar General Market and Family Dollar too.
Well, it sounds like right now you need to be focused on getting that high school diploma.
Yes, Your Honor.
I'm going to make it a condition of your bond that you work diligently towards that diploma,
Yes, Your Honor.
because that diploma will make a lot of difference on where you go next in life and whether you hang around doing dope in town and going back and forth in and out of jail, or whether you really have an opportunity to do something different. So you're going to be focusing on getting that diploma, or you can go to jail now that you're 19. You can be put in there with the hardened criminals. And your attorney, call here Friday to find out who your attorney is. And Missy, when do you want him to come to court again?
March 7th at 3:30.
Be here March 7th at 3:30 with your attorney, having talked to your attorney before then.
What was the time again, Your Honor? I'm sorry.
3:30.
Okay, thank you. And what is the number I need to call for getting the attorney?
620-583-8155.
Thank you, Your Honor.
You're welcome. So you know, you're going to find out who your attorney is. You've got your court date, you've got your bond. Same thing I told your friend before you, no contact with any of the people from that house.
I understand. I have been keeping in no contact with them since that day. I mean, there was a little bit, I was still around and everything, but as soon as I got all my stuff and everything out of the house and all that, I haven't had no contact with anyone from the home.
Okay, no alcohol, no drugs, no place where it can be made available.
Yes, Your Honor.
And who do you have with you today?
What was that, Your Honor? I'm sorry.
Do you have anyone with you today as you make this court appearance?
I have my stepfather right beside me.
Okay. All right, well, you can go at this time, Mr. Clater.
All right, thank you, Your Honor.
You're welcome.
This house was quite the party, ladies and gentlemen. I'm very upset.
Will now be on the record in 2023 CR 26 State versus Dustin Michael Harbor. The state appearing by and through County Attorney Jill Gillette. Mr. Harbor, where are you?
I'm at the courthouse.
Thank you, Mr. Harbor. You, sir, are charged with distribution or possession with intent to distribute fentanyl, approximately 86 fentanyl tablets on January 25th of 2023 in Eureka, Kansas, or in, I strike that, I don't know if it was Eureka, but somewhere in Greenwood County, Kansas. These are level 3 drug felonies, which mean if you were to be convicted of these charges, you could be looking at not a jail sentence, but a prison sentence. That is, in the Kansas Department of Corrections, you could serve, depending on your criminal history, anywhere from at least 46 months up to 83 months. 12 months in a year, you can figure out how many years you'd be in prison. On count 2, you're accused of having a pill crusher, a bottle, and a straw in your possession with the intent to either contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body. This is called possession of drug paraphernalia. It is a Class B non-person misdemeanor. That means that once you finally got out of prison, you could come back to the Greenwood County Jail and serve up to 6 months here. And you could pay a fine up to $1,000. Now, your fine on that distribution charge in count one could be up to 100,000. So do you have any questions, Mr. Harbor, about what you're accused of doing and the possible maximum penalties?
No, Your Honor, I understand.
And how old are you?
I'm 35.
Okay, and were you involved with the Hess house?
No, Your Honor.
Okay. Are you going to hire an attorney or apply for court appointed?
I'd like to apply for court attorney.
All right, tell me where you work, sir.
I work for Evergreen, North America.
And what do you make for per month with them?
Per month, I mean, it depends on overtime, but 3,600.
3,600 a month without overtime?
Well, that's with overtime, but I normally get overtime. I don't know.
Okay. And
That's
are you
kinda hard
married or
to-
single?
I'm single.
Do you have any children that you legally support?
Yes, Your Honor.
How many?
2.
So you're a family of 3?
Well, I was 50-50 on, well, no, we had no court custody.
I don't mean that you live with the children, but you're considered a family of 3 and that you support 2 plus yourself.
Yes, Your Honor.
And what do you pay per month for rent or mortgage?
Well, right now I'm only paying $300 a month.
All right. Do you pay anything for utilities?
Yes, Your Honor.
What do you
I
pay for those?
I pay $250 for electric, and then I pay for water is like, I don't know, 70, something like that. And I mean, I have Wi-Fi, cell phone bills, things like that, but
I know 86 fentanyl pills.
Any other bills?
like the Wi-Fi and the cell phone, and then I pay $1,100 a month child support.
Okay. And what kind of vehicle do you drive or own?
Right now I blew the motor in my truck, so I'm driving a '98 Ford Escort.
Is it paid for or do you make payments?
It's paid for.
I'm going to appoint an attorney to represent you, finding that you're at least partially indigent, and you'll call my office Friday to find out who that is.
Okay. Let me take that number again. I apologize. I wasn't sure how that was going to work, Your Honor.
Okay. Tell me when you're ready.
I'm ready.
It's 620-583-8155.
All right. Thank you.
You're welcome. Call Friday and Missy will tell you who that is. I'm going to order that you get a hold of that person and have a conversation with that person before you come to court again.
Yes, Your Honor.
And Missy's going to tell us right now when we're coming back to court for preliminary hearing control.
March 17th at 1:30.
March 17th at 1:30. You and the attorney must be back here, sir.
All right. I would also like to say that I don't know if you have any stipulations on anything, but I am enrolled in drug and alcohol rehab, and I'm doing all that.
Excellent.
So,
Good for you. That's excellent. That helps a lot. As long
Right.
as you're following what you're learning.
well, I hasn't started yet. They couldn't get me
Oh.
in for my first till the 20th. So, but I'm trying.
Okay. Because part of your probation is don't violate, or your bond is don't violate the law. And if you use drugs, you're violating the law, illegal drugs, that is.
I could definitely pass a urinary analysis. I don't know about a hair follicle for the amount of time, but I could pass a UA for everything but my prescriptions.
Okay. Sounds good.
All right.
All right. I will see you back here then at that date and time and keep complying with your bond.
All right. Thank you, Your Honor.
You're welcome. Bye-bye. Being
Oh,
in recess on Harbor, we're now on the record in 2019 CR 228 State versus Rodney Lee McGuire. Jill Gillette, County Attorney for the state. Mr. McGuire, is that you at the courthouse? Nope, there's Mr. McGuire in the automobile. Can you hear me, Mr. McGuire?
Yes, ma'am.
Oh, Mr. McGuire.
All right, you had a plea and sentence on January 20th, 2020, I believe, to unlawful possession of marijuana. You had a bunch of other counts dismissed. You were given a 120-day sentence. with probation. But then you apparently didn't comply with that. The state's alleging that you haven't made a single payment since
Yes, I have.
2020.
Yes, I have.
All right, you had 638, you're down to 339, so you've made some.
I'm trying. I'm sorry. I can't work. I had heart failure. You know, I told you before.
Yeah, you've had a
Sorry, I
couple.
kind of lost my voice. I've been sick. I lost my voice. Sorry.
Okay, well, we've had several failures to appear, several warrants to show cause. When was your last payment?
I don't know. It was like 3 months ago. I can't remember exactly. I'm doing the best I can.
You can't remember when you made your last payment?
No, it's been like 3 months ago, something like that.
And when was your last hospitalization?
I was in the hospital just a couple of weeks ago because my immune system's down because of my heart failure, so I get sick really easily.
Okay. Ms. Gillette, I'm contemplating sending costs to collections and closing this case, but I'd like to hear your thoughts on it before I make that decision.
Well, one of the issues that I have is ever since he was placed on reporting probation, he never reported to the CSO.
I'm sorry, I thought it was non-reporting.
Thank you,
Well,
Rick.
that's a whole different story.
He was changed to reporting probation.
I thought it was non-reported.
And he never reported since he was supposed to go on reporting probation.
I see that. He did start out on sir, just a minute, Mr. McGuire. You were put on non-reporting probation originally, but then because you didn't comply with your probation, it was transferred to reporting probation at a prior failure warrant to show cause hearing. You were placed on reporting probation October 15th of 21, and you haven't reported. Then we have a new warrant to show cause filed because you haven't reported. And then you failed to appear August 16th after you're picked up on your warrant. And they had to arrest you again in January, just this past month, to even get you here today. So, you know, you had me go in complete sympathy with the heart condition. But now I find out in a year's time, you haven't even shown up for probation. Year and a half, you haven't even made one attempt to contact probation. What do you have to say about that?
I thought it was I thought I didn't know I had to call and report or anything. I have so many appointments and stuff. I've been in the hospital so much. It's hard to keep track of everything.
When was the last time you had a job that paid?
I had a job since last year. I went to the hospital with heart failure a year ago today.
A year ago today was the last time you had a job?
A year.
You're cutting in and out. You're cutting in and out. Tell me
It's
that
not me
again.
cutting in. It's my voice. It's my voice. I can't hardly talk. But it's been a little over a year since I had a job.
All right, Mr. McGuire, I'm appointing an attorney to represent you. Did you have Shannon Cooper before?
I only owe 300 and something, right?
Yeah, but it's not just about the money, sir. It's about your non-compliance with court orders, not following the law. But it's not just about the money. If it were just about the money, I would keep this in collections and close the case. But it's not just about that.
He had Shannon Cooper before, Judge.
All right, I'm going to reappoint Shannon Cooper as your attorney. You call Miss Cooper before your next court date. Are you ready to take down her number?
No, ma'am, I'm not. Give me a second. All right, ma'am, I'm ready.
316-833-1154.
1154.
Right.
Thank you.
Tell her you're welcome. Tell her she's been reappointed, and that's where we are on.
And when's my next court date?
Your next court date, Misty's gonna give that to us right now.
March 7th at 3:30.
March
there you go.
7th at 3:30.
Right.
Okay.
Which if you
Thank
want to
you,
go
Judge.
ahead and get that paid off, that would be to your benefit. But if you can't, you can't. But you do what you can on that, but you also need to report to your probation. You don't probably even know who your probation officer is at this late date, do you?
I don't, ma'am. You really don't.
Well, call Ms.
Sorry.
You're welcome. Or you're okay. You're okay for now. March 7th at 3:30, I'll see you, and then we'll see how you are from that point forward.
Okay, thank you, ma'am.
You're welcome. You may go. Well, being in recess on McGuire, we're now on the record in 2023 FG3, State of Kansas versus Jeremy W. Newhouse. Mr. Newhouse is here in person with Jill Gillette, County Attorney for the state. Mr. Newhouse, you are charged with hunting without a license.
Okay, so
C9.
this one's about the hunting. I'm gonna. So what I'm gonna do is, so in her first part of the docket in the morning, she had a guy who is representing himself and put in motions, and she set a hearing date for this morning at 11:30. So I'm gonna play the part one of it. And then if we have time, I'll go to part two. If not, I'll either post the video or do it in the next live. So here we go.
Greenwood County Attorney Jill Gillette appears for the state. Mr. Kelly does appear in person and pro se. Mr. Kelly, we are here in a pretrial conference. You had asked for or demanded a jury trial in count 1, possession of marijuana after a prior conviction. Count 2, possession of drug paraphernalia. Count 3, operating a motor vehicle without liability insurance. And count 4, operating a motor vehicle with unlawful registration or expired tag. Are you still seeking a jury trial, sir? And you're muted. If you'd unmute, please. Find that red icon with the microphone with the line through it and click on it. There you
Okay, can you hear me now?
I can, sir. And are you still
Thank you.
wishing a jury trial?
Yes, I am. Also, the driving without insurance has been dropped. So it has been,
All right, so you were able to get proof of insurance to Miss Gillette,
yes.
and Miss Gillette, that has been dismissed.
Judge, I don't have that journal entry in front of me, but I can look it up.
I see it. October 18th, journal entry of dismissal. Now that
Judge, if I might mention also, I have registered for the PACER, but I have not been accepted on a district level, and I'm having trouble getting my papers filed for this matter. And so I would like to express on the record that there are some due process violations. Some are substantial, some are harmless, but I believe that we might need a motions hearing to discuss some of that matters.
very well. Now, you told me you'd applied for, did you say the PACER?
Yes, I have registered on PACER, but
Sorry, I'm not familiar with what that is. Are you saying PACER?
yes, that's correct.
And what does that?
PACER is the federal system, Judge. It's not the state system. PACER ECF is the federal system.
But I'm,
Okay, so that is something not available in the state court then, Ms. Gillette? Because like I said,
Correct.
40 years, I've never heard of that.
eFlex is our filing portal and Odyssey is the one that's available for the Kansas Judicial Branch.
Oh, okay.
I'm only familiar with Pacer and ECF because I was a federal attorney for a while and I have worked in many federal cases. And so I have access to Pacer and ECF and I use it frequently to double check federal cases on defendants that have pending cases in both courts.
All right, thank you. So did you understand that, Mr. Kelly? We use a different system than the Pacer. Sounds like our system is similar to it, but we call it, it's the Odyssey symbol, Ms. Gillette, is that right? It's equivalent?
Yeah,
to Odyssey?
it's called Odyssey, but it's through the Kansas Judicial Branch.
Okay, so now, does that help you any, Mr. Kelly?
we'll check into that. I work 9 to 2, sometimes 7, 8 o'clock at night. So I'm unable to actually go to the courthouse and file in person, but I do have quite a few papers that I do need to file in this matter.
Okay, well, those do not have to be filed in person because of the system we have that sounds like it's familiar with the, or consistent with the Pacer. You don't have to be in person to file, and you can file it at different times. So once you gain familiarity with that system, it'll probably serve your purposes. I do see you filed one document.
Yes, and also,
It just says, but sir, it just says motion to dismiss lack of evidence, KSA 22-3437, parenthesis 3, and KSA 22-3402, parenthesis 3, parenthesis 4. So I don't have those statutes open in front of me. I don't have them memorized. What are those in reference to?
well, the first one was in reference to the fact that we had started proceedings and I had not received drug lab. One of those statutes state that the drug lab has to be in 21 days or 20 days before proceedings start.
This is all about
I'm
weed.
not exactly familiar.
This is
with the
weed we're
second
talking about
one
here.
at
Old
hand,
dude that got caught with weed.
but you stated at that time that you were going to make a determination on that and send me a letter, and I never received anything on that at all.
All right, so I need to review that, it sounds like, and sooner rather than later. And I see the state has filed subpoenas. And it looks like that's about all that's happened.
Who has been filed, who has been given subpoenas for the state?
Well, I can tell you pretty quickly here. Looks like the state has subpoenaed Deputy Fisher.
Okay.
And any evidence he has. Okay, that's one. It looks like they have subpoenaed Emma Tursky from the KBI.
Okay, wonderful.
So she looks like she has probably done some lab work in that. And you're still wanting a trial, is that right?
That is correct.
And you still wish to waive your right to counsel and represent yourself?
I am going to be my own counsel. That is correct.
Oh.
Well, and will you be ready to go on this Wednesday if we go?
No, I would be ready for a motion hearing on Wednesday.
Look at you, Mr.
But
Kelly.
I feel due to the due process violations that we need to make some determinations on some of those.
Well, Mr. Kelly, Miss Gillette is prosecuting in Elk County today. She serves Elk and Greenwood. Miss Gillette, would you be available if I saved this till the end of the docket to take up that motion, or will you be tied up with other responsibilities?
Judge, I have a hearing now that Judge Lee's waiting on me for that was supposed to start at 10. And then I have a trial at 11. And so for today, I have availability. I'm not done with court this afternoon until 4:30. That's when I am available. And then I have time for motions sometime tomorrow. I'm with you, gonna be most of the day tomorrow.
Let's look at tomorrow. Missy, it looks like, do we have all morning open tomorrow?
Yes, we do.
First appearances. I don't know, does that give you enough time, Ms. Gillette, to be ready sometime tomorrow? Morning, would that work for you, like around 11-ish?
I could do something tomorrow around 11, Judge.
Or it looks like, again, Missy, we have 3:30 open.
Yeah, 3:30 is open too.
In fact, basically for, yeah, probably.
Okay, so now we're gonna
3:30. I
hop
don't
to
really want to set
today.
anything.
We're gonna hop to today with his motion hearing, and he's got a lot
Good
of
morning.
motions.
I can see you fine.
Thank you.
Hats off to Mr. Kelly for going pro se, though. Hats off.
Just exchange them back and forth. Well, no, you're going to email it, right, Missy?
That's Greg Kelly appearing as the accused.
Thank you, Mr. Kelly. All right, we were set for jury trial tomorrow with the defendant representing himself, having previously signed a waiver. At pretrial yesterday, Mr. Kelly, the defendant, indicated that he still wanted his trial. He still wanted to represent himself. And he wanted to be heard on a document titled motion that he had filed. And then about 5-10 minutes before the scheduled court date today, he brought in 7 or 8 documents, handwritten documents, some typed, each titled differently. Some of them seem to have the same titles though. All right, so let's begin.
He
with
really
what we're
doesn't want to
here
get
for
charged with
today,
this weed
which
at
was
all.
set simply to
Too much
address
effort for a pothead.
document that Mr. Kelly filed. And before I proceed on that, I guess I should go over the charges because those need to be addressed. Count 1 is the unlawful possession of the controlled substance THC and or marijuana after a prior conviction. And that prior conviction is addressed in one of the new motions filed. Count 2 is unlawful possession of drug paraphernalia, being marijuana roaches, which I believe would be considered rolling paper wrapped around marijuana and or THC in a small remainder amount.
That's why she said light.
Count 3,
Light.
no proof of insurance, which I understand the defendant brought in proof of insurance in a timely manner and the state dismissed count 3. So although it's referred to in the new motions, I don't believe it needs to be, but we'll address that at another time. Count 4, the registration offense. The defendant was pulled over initially for allegedly not having a current tag on his automobile, and the defendant addresses that as well. So with that being why we are here, there was a probable cause affidavit filed August 17th, and it was prepared and sworn to by Greenwood County Sheriff's Deputy Blake Fisher. The defendant had a surety bond that was filed August 18th of 2022. That was August 10th of 2022 and secured by Collins Bell Bonds in the amount of $7,500. We have the September 6th request for trial by jury. handwritten but filed by the defendant. We have a request for transcript. Not sure what transcripts really were of significance at that time, but the defendant asked for a transcript, apparently the first appearance. Transcript was completed. Did you pay for that and receive that, Mr. Kelly?
The transcript from what?
Okay, well, I don't know what somewhat means. Did you pay for it?
Yes, I did. I paid for discovery, if that's what you're referring to.
Well, when you ask for a transcript, you usually have to pay and then they give it to you.
Are you speaking of a transcript record of the?
Transcript record prepared by a transcriptionist. It says Jerry Ann Knoll completed the transcript of a hearing dated 9/6/2022.
That-
And it was 20 pages. Did you file and receive that?
The state requested the transcript, Your
Oh.
Honor, as the defendant made an admission on the record during his first appearance.
My apologies, Mr. Kelly. Thank you, Ms. Gillette. I made that wrong assumption there. Okay. Then 10/18, there was the journal entry to dismiss count 3. That was the insurance. So, Mr. Kelly, that's off the table. That's off the documents. We don't have to address that anymore. That's been dismissed, even though you addressed that today in some of your documents. your
Legal in
motions.
Jersey too. They have
And then we
court
have
all over the place in
subpoenas,
Jersey.
apparently, and I'm just looking at the caption. And based on experience, that was probably for the jury trial. Then we have a long list of new documents all filed today, February 14th. 1, 2, 3, 4, 5, 6, 7 motions. But the one we are here on dates back.
Subversion.
Well, I know I saw that yesterday, but it's not showing up in the document section, so let me look again. Didn't see it when I ran down the summer. It's there. Ms. Gillette, do you by chance have your copy of that document to show what date that would have been filed on?
The two-line to dismiss,
Right,
November 8th, Your Honor.
thank you. All right, we are here on a motion pro se filed by the defendant November.
And I still have
8th,
160 in the room,
2022.
so after this, I'm gonna put the bonus
3:22
clip.
PM,
If
and
it started
it
to
is
drop off, I
handwritten
was
and
gonna,
it literally says,
clip it, but I have two old
captioned
school lawyers
motion to
going at it
dismiss,
today,
blank space.
right after this.
And
Stay
I'm
tuned.
quoting, lack of evidence. KSA 22-34373, KSA 22-3402, parenthesis 3, parenthesis 4. That's all there is for this motion to dismiss. Is there anything you want to argue on this motion, Mr. Kelly? I will tell you that you should have by now the state's motion. If there's any of them that we can deal with today, and I think there are, even though the state has not had adequate time probably to even read them, let alone respond.
Judge, if
Just a moment, please.
She's always got that. Is that her life alert? Is that a phone? She got a Motorola pager? That ain't no cell phone ring. What is that? Is her Panera bread order ready?
All right, the first one on my screen is the one called additional violations are as follows.
Yes.
Ms. Gillette, do you have that one in front of you?
Hold on, I'm looking for all of them.
All right, I'll let you go ahead and look through them. And I'll see if there's a more straightforward one folks notice too.
Additional violation are as follows. Is that what you said?
Yeah, let's take a look
Yes.
at that one and see what we can do with it. Notice to the court filed by the defendant today at 10:52 a.m. And it alleges additional violations are as follows. 1, conflict of interest. I'm being tried by the state, judged by the state, and the state is also the victim. That's number 1. Well, what is your legal argument there, Mr. Kelly?
Well, I don't see how I can get a fair trial when the state has their hand in every aspect of it.
Oh,
Well, I think I understand what your argument is, but you have to understand all the people within the state of Kansas make up the state. And even though that is true, that we're all citizens of Kansas, if we live in Kansas and work in Kansas or work in Kansas, we do have different jobs to do. And Miss Gillette gets her paycheck, I believe, from the county of Greenwood, in that she looks out for that portion of Kansas known as Greenwood County. My job is one that gets paid by the state of Kansas as a judge. So Miss Gillette and I, we don't work with the same people. We don't represent the same people. Her job is to represent and protect. My job is to protect, but it is to protect both the defendant and the state, the citizens who are violated by the law. And I look at the evidence fairly impartially that she has. I look at your side fairly impartially. So no, Ms. Gillette and I are not conflicted in this case at all. The victims of the state of Kansas, some of them don't even know this is going to trial. Probably a very few of them do. Because as you said, the victim is the state of Kansas. When a law is broken of these natures, all of Kansas is affected by them. But again, there's just not a conflict, and I will rule right now unless Ms. Gillette, do you have anything? If you want to respond to what he has said or what I have said, I'm inclined to summarily dismiss that, but I certainly would listen to what you have to say about that as well.
Your Honor, I believe that this matter is not a conflict of interest. I mean, this is how the courts are set up. They each have a separate, different, and unique role. And the only reason for conflict of interest would be whether or not I had a personal relationship with Mr. Gregory or something to that nature. And there's no relief upon which anyone could grant.
okay. So I'm gonna
Mr.
hop.
Gregory, anything you want to say on that particular allegation?
Not at this time, Judge.
All right, well, I am ruling that number 1 of your additional violations, the conflict of interest, I am denying that. Number 2, you assert that the deputy stopped outside his executive branch of power and acted under the judicial branch and used those powers which constitutes him operating under the color of the law. I'm not sure I understand that, but you're welcome to argue that, and I will certainly entertain it.
Judge, when he
Here we go.
Chose to not take me to a judge upon my demand, he therefore took the responsibility of the judge himself. And therefore, he bypassed one of my major, a substantial right, which was the right to gather my witnesses before a judge before he proceeded with any other action. And he chose to ignore that
All right, Anna.
responsibility, which is part of his constitutional oath. And so he took it upon himself to use the judicial power, which he did not have privilege to.
So are you saying that he had a duty to bring you to the judge before he completed his investigation and made his arrest?
No, not well, in part, but mainly before I was booked or processed. I needed to see a judge before I was booked and processed.
All right, Ms. Gillette, are you in a position, are you prepared to respond to that?
Judge, I don't have all the research before me, but when an officer makes an arrest, he is to execute a probable cause affidavit, which is reviewed by the state and then subsequently by the court when the court reviews the sufficiency of the evidence based on the probable cause affidavit that is recorded with the complaint. The probable cause affidavit is not public record. It is part of the judicial file, but it is often under the confidential seal of the court because it often contains birth dates, addresses, or specific information. In this matter, a probable cause affidavit was executed and was recorded with the court, and the court then
The memberships. Google is
records
sending
that
me a
for
pin.
future use. So it would say that that is the proper protocol according to the statutes and the law under the state of Kansas, and that the officer in this matter followed his directive of having probable cause to effect arrest.
I object to that.
Welcome.
Judge.
You're just in
Like to say,
time.
go ahead.
It's a known constitutional right that I have the right to go before a judge in order to gather my witnesses and present them before a judge. Having been brought in on a misdemeanor, the fact that it was a misdemeanor, he had no right to arrest or to prosecute, and he took it upon himself to do both. And the support of probable cause that I am privileged to was not a affidavit in support of probable cause. It was an affidavit in support of a complaint, which gave the prosecutor the access to continue from that point, because she had to have an affidavit in order to write up the complaint. The affidavit in support of probable cause has to be signed by a judge. And so therefore he bypassed, to my knowledge, he bypassed that process. And again, causing me due process violation by violating substantial rights. He had I realized that, police officers, law enforcement officers do not take you to the judge, but I specifically demanded that I had that right. And when I voiced that right became in effect, and he chose to ignore it. And therefore he extended his allowed power and took it upon himself to be the judge and denied me of substantial rights.
Look at Webster's face.
Your Honor, the Kansas statute is Kansas Statute 222401. The officer that has probable cause to believe that the person is committing or has committed a felony, a misdemeanor, and the law enforcement officer has probable cause to believe that, the person will not be apprehended or evidence of the crime will irretrievably be lost unless the person is immediately arrested. We know that under the case law, that when you are in an automobile, it gives an inherent grounds for believing that the information can be lost because automobiles are inherently mobile, and therefore it is appropriate to arrest for misdemeanors when they are automobile related. And so therefore, there is grounds and statute that support probable cause arrest, which is what we have in this case.
If I might interject.
Final comment, sir.
You're gonna go up
On this
against
issue.
Gillette?
Okay.
Come on.
The statutes cannot be counterdictive of the Constitution.
Counterdictive?
In that respect, they are.
You just say
Also,
counterdictive?
what the prosecutor is not mentioning is that in the state of Kansas, in order to execute a probable cause without a warrant, he has to have exigent reasons. And his exigent reason was not listed as loss of evidence. Technically, he didn't list an exigent reason, although I believe that he was stating that his safety was the exigent reason. But that doesn't, that does not give him a right to do a warrantless probable cause unless he has exigent reasons. And he did not.
Well, the office, as Ms. Gillette correctly cited the law, the officer can arrest either with a warrant or under probable cause. And in this case, he made the probable cause arrest because of the possession of marijuana and paraphernalia. There is exigency in that. Again, as Ms. Gillette stated, because of the mobility of automobiles, the nature of drugs inside of a car, that evidence could have been lost. And the law is quite clear that that can and does create the probable cause for the arrest. So on that particular issue, at this time,
She's just trying to find it on the computer. She already knows what
I
she's
am
going
going
to
to find that the law relied upon is constitutional and does give the officer, based on the affidavit submitted, probable cause to make the arrest. And that was determined. That might be one we could have an evidentiary hearing on, but the affidavit, based on the affidavit the officer filed, does, in this court's opinion, amount to probable cause to support the arrest. But if we do, again, if we need to have evidence independent of the affidavit, that can be revisited. But at this time, that is denied. That portion of the motion. Counts 3, no affidavit in support of the warrantless search. Again, that
Thank you, Autumn.
affidavit is very clear. It is part of the file that the court takes judicial notice of, so that is denied.
Denied.
Sealed.
Denied. 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 Denied.
That does go through a sealing process, but you can get a copy of that if you haven't already.
He has a copy of the affidavit.
He does have a copy that was supplied when he asked for it originally.
It's
But
part of it.
Judge,
Okay. Mr.
I have to object because it cannot, in my impression, it cannot be an affidavit in support of probable cause unless it was signed by a judge. It was signed by a notary.
Well, the warrant, the inactive warrant was signed by the judge based on the probable cause affidavit.
And I never received that. So I would like
Okay,
to
well,
object.
let's sort through that because Ms. Gillette says you were given that. Let's make sure you know what it looks like since you're representing yourself.
And I would also.
And again, are you certain that you do not want an attorney to represent you, Mr. Kelly?
She's giving him one more chance.
Judge, I do not. I
boy.
really do appreciate you taking the time and patience with me. I know that it must be very frustrating for you.
He's
And
being,
I
they're both being very
apologize in
cordial
advance
about
for
it. This
that.
is very
But
cordial.
I am not comfortable with attorneys.
All right.
I have very little faith in the court system. I apologize.
Nothing to
Hey,
apologize
he
for.
has that right. That's what makes this country great. He has every right to feel that way and exercise his rights. Of course, it's a pink stapler. They are the two sassiest gals in the
Affidavit was
13th
filed
district.
August 17th
Don't you
of
know this?
2022.
Down to the stapler is even sassy.
And it should say electronically filed and then give you the information about the court case number. And then underneath of that, it should say affidavit, and it begins, I, Deputy Blake Fisher. You don't
Yeah, he
think you have that document?
stops it
I
light.
do have that document, Judge.
That is the affidavit.
Or
When
like
we refer
stopped at
to
0.
affidavit, that's a
Not
three-page
even like.
document. And the last page says, Deputy Blake Fisher, and it is subscribed and sworn to August 11th, 2022 by Gary Murphy, Notary Public. And then you should also have, typically there is a warrant signed by the judge. Do we have one of those, Ms. Gillette, that you see?
In instances where the person is arrested based on probable cause, the state must file a complaint against the defendant. There isn't an actual warrant because they were already effectuated upon arrest. So they are not re-arrested. Sometimes we issue inactive warrants. But in this matter, because he was already placed in custody, he was not re-arrested. And the case law on that is State versus Goodrow, 506 Pacific 3rd, 918. It's Kansas case number 121,
Always,
comma,
change the
944, decided in 2022.
All right, well, that is just, that's one of those things, even though we're in the same judicial district, the counties do it differently because historically Butler County does file what they refer to as an inactive warrant after the court has reviewed the affidavit. And then we still sign off on the warrant, even though it's labeled inactive, but it shows that the affidavit is approved by the court and supported. But Ms. Gillette, you're saying that Greenwood County does not do that practice. They rely strictly on the probable cause arrests in the affidavit. Is that correct?
Yes, for misdemeanors.
For misdemeanors. Okay, and the case law you cite is 121 Kansas 944?
Yes.
Okay, and you said
No,
that's
21 944 is the case number. There isn't a Kansas site yet because it hasn't been
oh,
published in
okay. Okay, so it's 506 P 3rd.
Pacific 3rd,
And it
Nine-
does it have a page number yet?
918.
Okay, and it's a 2022.
Mhm.
Okay,
And Your Honor, when it comes to misdemeanors, that goes over that in that matter. The defendant has to be brought before a magistrate within an appropriate amount of time, depending upon whether or not they remain still in custody or whether they are released from custody.
Oh, she's
The procedure under the Kansas
He's
law
just
has
shutting
been
him up.
followed in this manner. The defendant had a first appearance. His first appearance
Shut your mouth.
being on, he had technical issues on August 30th and was moved to September 6th of 2022, of which there is a transcript of the first appearance.
all right, so Mr. Kelly, what you might want to do is take note of that case she cited. What was the name on it?
State v. Goodrow.
Good.
Goodro.
All right, State v. Goodrow, and it's 506 Pacific 3rd. That's the set of books it's in, and 918 is the page where that can be found. So that may answer that question. I think the better practice, I like the practice better that we do in Butler, but I'm not going to say that Greenwood's doing it wrong either. I don't think we are.
Thank you.
I'm finding that we aren't. And
It's either
that,
infectious or obnoxious. Take it how you leave it.
Well,
Take
if
it
I
or leave
may
it.
object to that, I would like to object on that ruling.
well, I would suggest, sir, what you do is
Huh.
we rule on these, we pare them down.
Okay.
And if you want to file a motion for rehearing, because the state's probably not liking the way I'm doing this either. Now, I know Ms. Gillette likes to do her research and write her answers out. I'm trying to find a way to
As long as I have
streamline
that,
some of these volumes of
okay. As
documents.
long as I have that option. Thank you, Judge.
And deputy creating his own exigent reasons.
Remember, this is over drug paraphernalia, and I heard roaches.
Tell you what I'm gonna do. I'm gonna order that these be written up in more detail, because these are just too vague.
She's helping him out.
You'd write up more reasoning for these, and then I'm gonna give Miss Gillette time to respond in writing
Okay.
if she wishes, because you've got so many. I'd hope to.
I would appreciate more time. I did not have less than 24 hours to put this portion together. So if I could rewrite it and be more,
I would beg to differ with you there. I think you've had, since this case started in August, to do whatever you wanted to do on it, but
yes, Judge, correct.
this is going to be so cumbersome, and it's 1:45 and we haven't even gotten but into four.
This is such a pain in the ass.
Points of your multi-page motion or whatever you want to call it.
apologize.
Not multiple, so. Is there anything critical that we have to deal with today from either party?
The biggest thing was what I am calling a due process, the biggest due process violation, which is the complaint that I filed with the sheriff's department that I gave them for review prior to me sending off a claim. And it was based pretty much solely on the fact that I was not given the right to be taken to a judge prior to booking. That was the biggest due process violation. There were a couple more.
So excited for the
but
next
that
clip.
was the one that I had written a complaint out to the sheriff's department for review.
Okay, well, and that one I do, that one I think I've already addressed, that under probable cause, he didn't have to bring you to the judge, that he did act properly in that one. I'm very confident of that. Okay, well, let's set this over. We're not going to be having a jury trial tomorrow. So, and I'm going to have you limit this to get all of these pared down. I'm going to give you about an hour, Mr. Kelly, to argue everything you want to argue. So make sure
Okay.
you really refine these.
That's
and
fine.
Put
That's
them in
fair.
a way that they make exact sense to the state and to me as to what you're actually saying.
Okay.
And so Missy, can you give me about an hour? And did we reset? Let's reset this for jury trial June. What's that date? June 13th for pretrial?
June 12th for a pretrial and June 14th for the jury trial.
All right, so I'm going to
The
move
jury
your
trial.
jury trial.
Here we go,
to
baby.
14th and 15th. Your
This is Rocky versus Drago. Knockdown, drag out. If you like old school gunslinger, ambulance chasers going at it, we got it right here. Only seen on time served. In Judge Goggins' courtroom. You know I love Goggins. Here we go.
It's $15,403.41.
Oh,
this is not the kind of case where discovery gains show that defendant has any offset or credit. He can't prove anything by a preponderance of evidence because he put that his client over 6 months. I get it, but that's not a legal defense on corporal. And I have judgment on that. I rest.
Mr. Pabst? Okay, thanks, Judge. Yeah, we do have a legal defense, the statute of limitations. All these transactions happened way more than 6 years ago, okay? He's trying to hang his hat on a phone call that allegedly Harold Horton made a payment within a 6-year period of time. But all the basis of the 15,000, all those transactions happened way more than 6 years ago. And I challenge that he made a payment on the phone. court. He sent requests to admit, and Harold Horton's had a stroke. He's got a brain injury. Can you hear me, Judge?
Yeah,
I lost the
yeah, thank
visual.
you.
He's on a roll.
He's had a stroke. He's got a brain injury. He's got absolutely no memory of any of this, and that's when I responded to the request to admit. With all due respect to the plaintiff's counsel, I think he doesn't understand the rules of request to admit. Because if that's not a legitimate reason.
Sorry,
to
guys,
say,
just
"Look, I can
listen.
neither admit
This
nor
was
deny,"
me.
because he
My
doesn't
rookie
have a
mistake.
memory, I
Just
don't know
listen.
what would.
No, it cut off. Did you hear them two going at it? Oh,
And under
here we
Michigan
go.
law, the assignee stands in the shoes of the assignor. So therefore, that first affirmative defense fails. The affirmative defense number 2, the amount claims are due and owing are inaccurate and untrue. Wait a minute. I had discovered, and I said, show me any offset or credit. Show me that there's any irregularity. I got nothing but objections to my discovery. Therefore, because I submit defendant can't produce any affirmative defense or competent evidence, that affirmative defense fails. Let's look further. Plaintiff has no contractual or other relationship with defendant, giving rise to a duty to pay anything. That's already been answered in my first argument as to the first affirmative defense. Then the next affirmative defense, plaintiff has no standing whatsoever to bring this lawsuit. I beg to differ. All assignments are all properly entered into the court record, and when I brought all my discovery, I had nothing but objections from the defendant who was playing games with discovery and stalled.
Okay, he's had a stroke, he's got a brain, he's got absolutely no memory of any of this, you know, and that's what I responded to the request to admit. With all due respect to the plaintiff's counsel, I think he doesn't understand the rules of request to admit. Because if that's not a legitimate reason to say, look, I can neither admit nor deny, because he doesn't have a memory, I don't know what would be, okay? So it's totally, and that's the basis for his personal attack on me. That's nonsense. He can't, he's got to prove his case. He's got to prove that these charges were incurred within 6 years, looking backwards with a telescope. And he can't do that. And he's trying to bootstrap his way into it with an alleged payment by telephone, you know, within the 6 years. And there are 2 summonses here if you check the court record, Judge. There's one in April, as he says, but there's another one, I believe, June 18th. Okay, and I think that June 18th one was the one that was used to effect service. Okay, just to clear the record up, all right? But I don't think he can prove that the basis, the lion's share of these charges were incurred in any transactions within 6 years looking back. He just can't do it. And he's got to prove his case.
I have. Now let me tell you why. Because under the Truth in Billing Act, which I've included in my brief, you basically have 60 days when you have a credit card to show a dispute in payment. That was not done by Mr. Horton, not at all. By the way, unless Mr. Pabst can show me another case number, a different case number for the summons that he's pledging that was served on him in June, it's the same case number because, again, the summons was extended. And you can do that. And it was done here. It's the same case number. And filing the lawsuit tolls the statute of limitations. So we can use all sorts of legal platitudes that says, oh, I can answer this. Yeah, you can answer and object. But by the way, at the time of a motion for summary judgment, that's when your discovery hits the ground and you have to prove at the time of a motion for summary judgment that you have a legal defense. And there's been nothing. I get the fact that Mr. Horton's sick. I respect that. I respect the fact that he can't remember getting this. Then show me his bank account for my son's second production of document request saying, give me the bank statement. Not complied with. Just give me the bank name, where he worked in, or where he banked in twice. I'll subpoena them. But the fact of the matter is, now is the time to prove an affirmative defense. Not saying he's sick, he can't remember. Oh, no, I'm sorry. I proved my case. And everything else now is something that he can't prove because he can't do it at the moment. Therefore, judgment is properly laid on my motion. I ask for judgment death.
Mr. Bruce, I do have a question for you. Do you have, I'm looking through the file, I'm looking for some document that shows me a payment was made by phone.
Look at probably attached to my motion as Exhibit 8 of the
Exhibit 8
request for admissions. It says GM card, and it says it's the payment cycle from 22nd, 2016, August 23rd, 2015, and there was a payment in July.
Okay, I'm sorry, you said it's Exhibit 8?
Yeah, so it's Exhibit 8. Now, if I filed this lawsuit in August of 2020, yeah, time's hard. But it wasn't filed in August of 2022. It's filed in April.
I do have, just for both of your sakes, I'm looking at the original summons. The issue date was April 18th, 2022.
Yeah.
Had an expiration date of July 18th, and then it was extended second summons was issued June 23rd, 2022. So, Mr. Pabst, on that, it was issued April 18th, 2022.
Yeah, I hear you on that.
Okay. Then the only thing that's begging the question for me, Mr. Bruce, is not that I don't trust what you're telling me, but I just can't find Exhibit 8. You said it's attached to your motion somewhere?
Well, it should be attached to my motion, it was attached to my request to dismiss. I did please attach all of my motions.
I'm sorry, it's under.
Okay,
it's under the
guys,
request for
I'm gonna
admission?
cut it.
Is that- I'm sorry.
We're gonna pick up tomorrow. I appreciate everything. Save Mando. Save all your law creators. I thank you. We were on for 3 hours. We were going at almost 200 strong. I thank you very much. I'll be live tomorrow night. See you guys tomorrow.
All I have in here is just a statement saying the payment was made.